recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. And good morning, and welcome to the Massachusetts Appeals Court oral argument session for October 22, 2020. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. Nonetheless, we'll follow the same rules and customs as in the regular courtroom, except you don't have to stand. Once we get going, the clerk will display a countdown clock. Each side has 15 minutes to argue, and there's no rebuttal. Only one advocate will be speaking at a time, and the session clerk will mute the other advocate when it's not your turn. However, please stay on the video so we know you're still there, and remember that we can see you, so try and keep gesticulations to a minimum. And as you know, the proceeding is being recorded and archived. It will be available. It's available now. It will be available later on the YouTube channel and on our website. As always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, there's no penalty if you finish early. And with that, I'll call the first case for today, which is Commonwealth versus KEON Adams, 2019 P1142. Attorney Smith.
Good morning, members of the panel. May it please the court, Joseph Smith for Mr. KEON Adams. Your Honors, this case arises from a traffic stop. Mr. Adams was driving in the Mattapan and Dorchester area of Boston when he was pulled over by two state troopers. The troopers didn't witness Mr. Adams commit any moving violations. He wasn't speeding. He wasn't driving erratically. It didn't appear that Mr. Adams was impaired in any way. The basis for the stop, as according to the troopers, was a single crack in Mr. Adams' windshield. And as we know, a traffic stop is an act of constitutional significance. It has to have justification under both the Fourth Amendment and Article 14 of the Mass Declaration of Rights. Here, the proffered basis for the stop, the fact that there was a single crack in Mr. Adams' windshield, is not adequate to support the stop because there's no specific statute that provides for or allows the police to stop an individual based solely on a windshield crack. And the inspection regulations, as they appear in the Code of Mass Regulations, don't themselves provide an independent justification for the stop. And further, there's no evidence that Mr. Adams's view was impeded under General Laws Chapter 90, Section 13, such that it would have been appropriate for the troopers in this case to conduct the stop. And therefore, because the stop was unjustified, all of the evidence that was obtained, the subsequent firearm that was discovered on Mr. Adams's person after police interacted with Mr. Adams, issued an exit order, conducted a pat frisk, discovered the firearm within his waistband. Because the stop was unjustified, the evidence should be suppressed as fruit of the poisonous tree. And Mr. Adams's.
I just want to ask you.
Yes, Your Honor.
What I understand, you think you just said, I understand it from your brief as well, is that you're challenging the initial stop, but you're not challenging, if that was okay, you're not challenging anything that happened after that. But you're saying that nothing should have happened after that.
Correct, Your Honor. Correct, Your Honor. We're not contesting the validity of the exit order and pat frisk.
Right. And counsel, so you agree though that the police can stop an individual based on a perceived safety issue?
Well,
deal with the safety issue.
In certain instances, perhaps the police can certainly stop a vehicle for certain moving violations and even certain equipment violations that are enumerated in the relevant motor vehicle statutes. General Laws Chapter 90, I believe, Section 7A or 7 enumerates those equipment issues that would form the basis for a stop. But in this instance, the motion judge seems to have ruled that the inspection regulations themselves provide a catch-all justification for an officer to conduct a motor vehicle stop. And that is something that Mr. Adams disagrees with. these are regulations that pertain to or govern licensed motor vehicle inspectors conducting annual motor vehicle inspections, and they sort of outline the parameters under which a vehicle can be issued a new inspection sticker or rejected. That's something that's conducted on an annual basis.
Is the only
Yes, Your Honor.
problem with having a crack in the windshield that it may impair the driver's visibility?
I'm not sure I understand the question. Could you
Well,
perhaps ask me in a different way?
the regulations about inspection have to do with safety, right? So in other words, all of the various things that the inspector has to inspect on the vehicle have to do with safety and or emissions, right?
Yes, I mean that's in part what the regulations reference, safety, and of course these are inspections that are conducted on an annual basis. So these are the legislature and or the registrar deemed it appropriate that these inspections take place on an annual basis rather than more frequently. But for example, some of the other things that yeah, in answer to your question, then yes, to some extent it involves safety, but does that create a per se justification for a stop where there's an issue that would cause a vehicle to fail its annual inspection? I would answer that question in the negative.
Well, counsel, not just the consequence that it might fail an inspection, but a cracked windshield could result in more damage, and it could eventually injure someone.
Well, I mean,
right? So it's a safety concern in that sense.
I think the key word is eventually, and the motion judge uses this so-called, what I reference as the shattered windshield hypothetical, and indicated that taken to its extreme, Mr. Adams's argument would be such that if the vehicle had an entirely shattered windshield, that it couldn't be pulled over until it was subject to an annual inspection. I don't think that's the case. I think that would, in fact, I think in that instance, that would be clear evidence that the driver's view was impeded, a completely shattered windshield.
Again, you're bringing back to the issue of impeded view when there's another present issue, and that's safety, the potential for harm.
Right, but I mean, that there's no evidence that there was a safety issue in this case. There's no evidence that Mr. Adams's view was in fact impeded. There was no problematic issues with his driving. He didn't have to, the trooper didn't testify that he had to sort of peer around the crack.
But the safety issue isn't whether he can see through the windshield properly to drive. The safety issue is the potential for that crack to get bigger or and harm someone in that sense.
Well, yes, I mean that's a safety that's something that could become a more severe safety issue, and it's something that ordinarily pursuant to.
So isn't that something that entitles an officer to pull you over and say, "Listen, you got to take care of that. That could be a problem."
Well, I think that broad of a reading of the inspection regulations really creates a catch-all justification for arbitrary traffic stops, and it really creates a foothold for the kind of pretextual stops that in Commonwealth versus Long, the SJC stopped short of saying that all pretextual stops are unconstitutional, but at least in Justice Butt, I believe's concurrence, there was the court, the SJC expressed the view that perhaps we should prohibit all pretextual stops. And I think in this instance, when you look at
what do you do with footnote 11 of Long, where the SJC said that a stop based on a safety justification might stand on a different footing?
Well, that's the key wording. It might. I mean, if we read the inspection regulations so broadly as to hold that anything at all that would cause a vehicle to fail its annual inspection is a basis for a police officer to stop a vehicle, then you have to hold, which I think is unreasonable, that a trooper could stop a vehicle because of windshield wiper scraping or decals on a windshield that might somehow encroach upon the critical viewing area. I think And that's an item that's in the same section as that deals with single line cracks over 6 inches. And particularly in today's day and age with the gig economy and ride sharing services and so forth, you have many vehicles that have decals for companies like Uber or Lyft. And all that would be required then of an officer who wants to engage in, for example, a protectional stop, he needs a foothold in order to create some kind of pretext for justification for the stop. You could say something along the lines of, well, this person had too many decals on his windshield. That's a safety issue. So I needed to stop
How do you
him.
get around the language in Chapter 90, Section 13 that prohibits a driver from having anything on or in the vehicle or anything which may interfere with or impede the proper operation of the vehicle? So may interfere with.
Well, that's I would say Commonwealth versus Brazo, which I referenced in my brief as well, where the driver in that case had items hanging from her rearview mirror, and the police officer attempted to justify the stop by saying that those items may have impeded her view, and therefore he needed to conduct a stop. Well.
But there wasn't a risk that those items were going to shatter and possibly hurt either the driver or a passersby, as might be present when a crack is in a windshield.
I don't think there's enough evidence, Your Honor, in this record that the windshield, Mr. Adams' windshield, was at imminent risk of shattering. I think we have a single crack, which over time may have progressed to such an extent that perhaps the windshield could have shattered, but under these facts, we don't have a windshield in such a state of disrepair. So I think that the facts of this case are distinguishable.
On these facts, is the crack into the quote critical viewing area?
So yes, it's not contested that the vehicle would have failed its annual inspection if in fact it had been inspected on the day of the stop.
But it's also directly in front of the driver, isn't it?
Well, I mean,
it's not just a past inspection; it's directly in front of the driver.
I mean, it's in front of the driver. Yes, I mean the windshield itself, it's in its entirety is in front of the driver. But I think I would circle back to the fact that we don't have any evidence on this record that this crack in fact impeded Mr. Adams's view, and the motion judge's ruling essentially would have us hold that any crack in a windshield that would cause a vehicle to fail its annual inspection is per se a safety hazard and a justification for an immediate stop, which I don't think that we can read the regulation so broadly. And just as the inspection regulations themselves don't provide an independent justification for a police officer to conduct a stop. They're regulations that are just based on the scope and applicability of the regulations themselves. They govern licensed inspectors. There are a number of different statutes that enumerate certain, for example, equipment violations under which the police could conduct stops. But yes, Your Honor.
You say you choose a comparison of stopping somebody for an engine light being on their dashboard. The Commonwealth responds, it's more like a tail light or a headlight. Why doesn't their analogy work?
So I think that a taillight or headlight is different than a cracked windshield because that puts other motorists much more at risk. So, for example, if a vehicle is driving at night without headlights or taillights, other motorists cannot see that person. Whereas where we have a motorist driving with a single crack in his windshield and there's no evidence that impedes the driver's view, that's not the same sort of safety hazard. So that's how I would respond to that line of argument.
Not a question of that's allowed, specifically allowed by a statute.
Well, I mean, that's another point, Your Honor. By statute, the police are specifically allowed to stop a vehicle for a broken taillight and or headlight. So yes, and nothing in the relevant statutes references or gives the police authority to stop a vehicle for a single crack in a windshield. Just briefly, because my time is expiring, I would like to reference, so the motion judge in the motion judge referenced the fact that a Rule 128 decision, Commonwealth versus Jackson, the court decided that the stop in that case was justified based on a single windshield crack. Of course, that's not binding precedent, but I'd also like to point out, it appears from my review of the docket that Jackson, in fact, proceeded in his appeal pro se, which I think is relevant. And there were a number of issues in that case that Mr. Jackson raised. By my count, I think there were 11 separate and distinct issues. I think that that's noteworthy. And with all due respect to that panel that decided that case, I think that it seems as though they sort of, in a perfunctory way, addressed the stop, but didn't really conduct a thorough analysis of whether the police were justified in that case simply for stopping the vehicle because of a crack in the windshield. Also, the SJC's recent decision in Torres Pagan, as I referenced in my reply brief, the court's reference to the fact that the stop in that case was justified based on a cracked windshield and an expired inspection sticker. That's purely dicta. The parties in that case never challenged the validity of the stop. The issue wasn't briefed. In the cases that the SJC cites to basically support that proposition, all involve basically moving violations. So, for example, one moment, Your Honor. I see actually that my time is expiring. If the court does not have any further questions, I would rest on my brief.
Seeing none, thank you very much.
Thank you, Your Honor.
Attorney Wakeford.
Good morning, Justice Massing, members of the panel. May it please the court. I am Donald Wakeford, and I represent the Commonwealth in this matter. The motion judge correctly found in this instance that the trooper in this case observed a large crack within the vehicle's critical viewing area of the windshield, and that the officer intended to cite the defendant for civil infraction when he pulled over the defendant.
What civil infraction would he cite him for?
He could cite him for a violation of the applicable safety standards under General Laws Chapter 90, Section 20. And I actually want to draw this court's attention to a particular case, which is actually cited in the defendant's brief. It is not really addressed in the Commonwealth's brief, but that case is Commonwealth v. Rivas. And I apologize if that's a mispronunciation. I think there are about 3 different ways of pronouncing that name, but it's R-I-V-A-S, cited at 77 Massachusetts Appeals Court 210. And at page 218 of that decision of Rivas, this court stated explicitly that driving with any uncorrected safety defect, including not readily visible defects of critical safety equipment, would violate General Laws Chapter 90, Section 20. So this court in Rivas actually explicitly stated that a violation of the safety standards would give rise to a violation which is not allowed and for which a trooper could pull over a citizen. This court and the SJC have ruled numerous times that a person can be pulled over for a civil infraction. And actually, just since what we're really trying to establish here is the legality, the justification for the stop, we understand that all that has to be established is that the officer had a reasonable suspicion that there was a civil violation occurring. And in this case, unlike cases where there may have to be evidence introduced to establish what the justification for that officer's belief was, we know here there was a readily visible and outwardly apparent safety defect, namely a very large crack going through right in front of the driver through the critical viewing area of the windshield. So for that reason, Justice Massing, the officer was well within the law to pull over and attempt to cite the defendant for violation of a safety standard. So the defendant's repeated assertion that these regulations do not provide on their own a basis for a stop, I would respectfully reply with that language from Rivas, as well as the way that General Laws Chapter 90, Section 20 interacts with General Laws Section 7A and 31 to establish the regulations which are put forward by the Registrar of Vehicles. Essentially, what we do not have challenged here are the facts that there was a crack in the windshield. We do not have a challenge to the fact that this vehicle would not pass inspection if it were brought up for inspection on the day of this arrest. Instead, we just have a question about whether this stop was legally justified. And because an outwardly obvious and visible safety defect can give rise to, can provide a justification for a lawful stop, the officer was within the bounds of the law when the stop was effected, and the defendant's claims must fail. That is the basic position of the Commonwealth in this case.
What if it's not a?
Go ahead.
What if it's not a? It's something that maybe, trying to think of it, that may be apparent to be something that could be unsafe, but it's not specifically addressed in a particular regulation or statute. Does an officer have the ability to do that? Just generally, they could see something that maybe not specifically is dealt with in a statute or regulation, but it seems unsafe to the officer.
There is a general caretaking function which has been mentioned in numerous cases before this court and the SJC. Generally, none of the courts have gotten quite to the point where they have elucidated exactly how far that general caretaking function extends. Certainly, policy-wise, we want to encourage troopers to make stops for valid safety reasons. I can't think of a single common sense reason why we would not want vehicles which are patently and visibly unsafe to be stopped. However, I cannot provide you with specific guidance provided by either this court or the SJC as to how far that sort of general caretaking function extends. However, in a situation like this was actually a training run with the trooper who was taking a recently graduated trooper through the Dorchester-Mattapan area to demonstrate how stops are to be effected. And the trooper actually specifically knew the requirements for the critical viewing area and what exactly a crack in a windshield, where it can be and where it cannot be. So I cannot speak to a more general, possible, sort of more nebulous safety concern, but a specific concern like this one is certainly encompassed by General Laws Chapter 90, Section 20.
Well, what if a vehicle had, say, a rope hanging out the door that was dragging behind it, and that's not in anywhere in the inspection regulations, and a police officer saw a rope hanging, say, 20 feet behind the car out the door and onto the road, would that justify a stop?
Certainly, I would be comfortable if representing the Commonwealth arguing that a stop in that case was justified obviously under the general caretaking function, because that is an extremely unsafe condition. But there would also, I don't know enough about the multiple and various safety regulations which have been codified either by statute or in the regulations, which would perhaps pertain to objects hanging out of the doors of vehicles. But I think in a case like that, Justice Grant, where there is such an obviously dangerous condition, that it would actually be contrary to the goals of public safety to say that officers could not make a stop in that situation. And I believe that footnote 11 in Long, which Your Honor addressed earlier, is actually sort of considering a situation like that or like this, where there is an obvious safety concern, and that elevates these situations away from the pretextual stops that Long was concerned with. I think in that case, Justice Grant, the Commonwealth would say that was a justified reason for a stop.
Well, speaking of Long, are you at all concerned that this trooper testified that as a member of the community action team, he could focus on high crime areas at his will and basically wait at the corner of Columbia Road and Geneva Ave, looking for somebody to commit a traffic violation and then stop that car?
Obviously, Long has provided us with things that both the state troopers and the Boston Police Department, every other law enforcement agency, are going to have to evaluate whether these free-ranging zones are going to continue to be allowed. It does certainly Long provides us with direction as to maybe how those policies should be revised. However, I am less concerned in this case because we have a concrete example of a safety defect that, again, elevates this out of the realm of the pretextual stops that Long was concerned with. Instead, here we have an actual present and continuing danger to this defendant and other drivers on the road as a result of this crack. It's the same as if the muffler was hanging by a thread from the back of the vehicle, or any number of other safety violations that could give rise to unsafe conditions and lead to people being hurt. So I am less concerned in this case.
Evidence here that it would have failed the inspection, but is there evidence that the crack was actually impeding the driver's view?
That was the finding of the motion judge, and that was based upon, I believe, page 9 of the hearing transcript. The trooper testified that the crack entered into the critical viewing area. There were actually also 3 photographs introduced, which show that the crack was moving through this sort of heart of the windshield wiper's radius, which is how the critical viewing area is defined. So I think there's ample evidence in the record that this crack certainly met the standard and the definition of a crack that would violate the applicable safety regulations.
But I mean, is that the same as saying that it actually impeded his view? I mean, Attorney Smith argues that there's no evidence he was driving erratically, or.
I see. I understand, Your Honor. You're speaking of Section 13. I actually don't know that the evidence in this case established a concrete violation of Section 13. However, I do think it established that the officer had a reasonable suspicion to investigate and to see if this was a crack that would impede a driver's ability to operate the vehicle to the extent that it could violate Section 13. So I think actually the stop is justified under Section 20. However, the suspicion, the outwardly visible crack, it gives rise to a reasonable suspicion that it could be a violation of Section 13 as well, which justifies the stop.
Is there a specific section for headlights and taillights other than Section 20?
I believe there is, Your Honor. I believe that there are a few different violations which have been specifically codified by the legislature. I apologize, cannot cite to that specific headlight or taillight statute in this moment. But I know also, for example, window tinting has been specifically outlawed by a specific statute independent of Section 20. So there are some violations which the legislature has seen fit to codify. Section 20, however, allows the officers, if there is a reason to suspect that there is and I want to use the language of the Rivas panel again, an uncorrected safety defect, and especially an outwardly visible one. I'm sorry.
I have to. I hadn't read Rivas carefully until you mentioned it. In fact, not that I actually read it carefully. I'm listening to oral argument, but it does actually mention that the reason that they knew there was an undetected safety standards because he had failed inspection. There was actually a red inspection sticker. So this might be more along the Pagan Torres type of thing where they stopped him not for the violation but for the failed inspection.
Certainly, Your Honor, and I'm not trying to say that this is that this is a sticker case. What I'm saying is that the justification provided or the reasoning provided by the Rivas court was that driving with an uncorrected safety defect is a violation of Section 20. And therefore, and in that case, the sticker was actually significant because the officer did not know which safety defect could be the reason for that red sticker. By contrast, in this case, it was quite obvious what the safety defect was. It was the giant crack in the windshield. So I actually would posit that the reasoning in Rivas, it makes this case, this is actually a stronger example of the concerns provided by the panel in Rivas, because this is an obvious and outwardly visible safety defect. And the Rivas court takes pains to point out, even including not readily visible defects such as the frame, tires, or brakes, that we're actually in a stronger situation for a stop here because the officer with his own 2 eyes could see the violation. So I think this is actually stronger than the red sticker. And what the Rivas court was telling us was that you cannot drive around with these unsafe conditions on your vehicle. And this is sort of where we get to the example provided by the motion judge, which is that if we follow the logic that the defendant urges this court to adopt, then there will be no basis to pull over vehicles with outwardly or with obvious safety concerns until their inspection comes up every year.
What if it was a crack less than 6 inches that was on the passenger side of the windshield?
If it is not in violation, I think then that's an entirely different case, Justice Grant, entirely. Because if what we have here is I think a section 20 or a section 13 concern that motivated the officer to pull over the vehicle. If you don't have a crack that meets the standard for a crack within a critical viewing area, then I think you have a different case. And I think a crack outside of the definition of a critical viewing area, which is I think what you just described, would
No,
mean
I'm saying within the windshield wiper area, but on the passenger side, and more than 3 inches, but less than 6 inches.
I am not sure. I haven't looked at the regulation to remember whether it is only on the driver's side, but I think regardless, if it under the definition of critical viewing area is more than 3 inches in that defined area, then as long as the officer has a reasonable basis to think that crack to see and believe that crack could be there, then under section 20 or section 13, a stop is authorized. And perhaps we have a problem with probable cause, but we are simply trying to find a justification or to determine whether the stop was lawfully justified. And I believe we do in this case. Finally, with regard to the Jackson case discussed in the motion judge's order, the Commonwealth continues to maintain that the reasoning in Jackson holds up. Would also note that the panel in the Jackson case was Justices Meade, Green, and now Justice Cipher. The reasoning of that case holds up, and it was right for the motion judge to rely on that case in reaching her conclusions. Unless this panel has any further questions, I believe that the Commonwealth's position is clear, and I will rest on my brief.
Seeing none, we'll take the case under advisement. I just want to say to both of you, if every advocate the rest of the day is the quality of you guys, would be a really good day. So thank you very much.
Thank you, Justice
Very
Massey.
helpful.
Thank you very much.
All right, we are live and recording.
Good morning and welcome to the Massachusetts Appeals Court oral argument session for October 22, 2020. As you know, this argument is being held on Zoom and being live streamed on the Appeals Court YouTube channel. We'll follow the same rules and customs as in a regular courtroom, except you're not required to stand up. Once we get going, the session clerk will display a clock where the seal is. And as in the usual courtroom, you each get 15 minutes with no rebuttal. When it's not your turn to speak, you will be muted by the clerk. But please stay on the screen and remember that we can still see you. So please keep any reactions and gesticulations to a minimum. The proceeding is being recorded and archived, so it can be viewed now and it can be viewed later, both on YouTube and on the Appeals Court website. As always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, there's no penalty if you end early. And with that, I'll call the case, which is Commonwealth versus Gaskins, 2020 P52. Attorney Steele for the defendant.
Good morning, Your Honors. Lisa Steele for Mr. Gaskins. The evidence was insufficient to convict Gaskins under Sonati and Rodriguez. The Commonwealth, even in the light most favorable to it, did not prove whether Mr. Strange was the buyer or the seller of the cocaine, or whether he had it on his person all along. Strange is observed by one or the other officer from the interaction to being stopped seconds later. He's found with a rock of cocaine in a hard plastic container in his left shorts pocket. There's no testimony that he manipulated his pocket, he reached into his pocket, that he did anything with this container about the size of a cigarette case. This is akin to Rodriguez, where the contraband is found wrapped in a dollar bill, and the court says it's conjecture to assume that the person could have wrapped it while under continuous observation. Yes, Officer Goggins, the observing officer, has training. So did the officers in Kearse, in Morgan, Rodriguez, Sonati. Training isn't enough. He doesn't see what's exchanged, if anything. Gaskins goes into his apartment and leaves. When he leaves, he has the unremarkable sum of $44. He could have been the buyer and left the contraband in the apartment or consumed it in the building.
Well, I want to ask you about that. I mean, I agree with you. This is a tough case on sufficiency. We have to look at it very carefully, but I'm not so convinced by the buyer-seller thing. The Strange has drugs. Your client's got money. In terms of equipoise, I don't think that's equipoise. Or do you have any cases where it's not a question of who's the buyer and who's the seller? Is Rodriguez that? Is Sonati's not that?
Rodriguez, I think, is partially that. The problem in part is that Officer Johnson, who's the one that stops and searches Strange, is never able to affirmatively state that Strange does not have money. What he says is they reached into the pocket, they found the cigarette case, they found the contraband in the cigarette case. At that point, they stop and they don't seize the case, they don't seize anything that's contraband. They testify it as policy not to do so. We don't know if he had anything of value on him that, I don't know, coins, whatever, jewelry, we don't know.
Well, what do you do with the fact that the police officer testified when asked, were any other narcotic substances found on Mr. Strange's person that evening? Answer, not that I'm aware of. I didn't find anything other than that. That's at page 71 of volume 3. Is that give rise to an inference that there was nothing else in his pockets? And therefore it must have been the drugs that was what he took?
The defense attorney asks about that, asks a little bit about the search, and specifically argues in the request for judgment notwithstanding the verdict that he never testifies there's no money. Now, the testimony about Johnson's search is somewhat vague. So we don't know. We're speculating. There's no money, or as I said, or some other valuable small object. The Commonwealth will probably talk about the prior encounters with the women. I will note that these happen in the foyer of the building. They're different. They take place in a different location. And still, the officer, Goggins, can't see an exchange. He sees something he's suspicious of, but he can't see what's happening with the hand movements. There's no phone. There's no weapon. There's a lot of ambiguity in this case, and I think it does fall within the Sonati, Rodriguez, and so on line of cases. Let me turn briefly to the second issue, if I may.
More question on the first issue. Was there any description of the packaging of the rock of crack in the glasses case?
It appears to just be there. There's no description that's in any sort of plastic or other or a baggie or anything else. It seems to be described as just having been there. The chemist does not testify to a weight, although I believe the contraband itself is an evidence. It's a relatively small rock. We have no testimony on street value. We don't know whether $44 is the right amount, is a different amount, higher, lower. The money's not described. Was it tightly folded as though it had been part of this discrete exchange, or was it just, or was it uncreased? We don't know. There's too many vaguenesses in this case.
What about the time frame that had elapsed with the defendant going in and coming back out? What was that time frame?
It's about 5 minutes that he's out of sight. Turning to the second issue, something odd happens in this case. The day the defense asks for the viewing location so they can send an investigator out. They're given that location. They go out, they take some pictures, they come back, they come to the court on a motion to suppress and are told, this is not adequate because you don't have the low light binoculars. Your investigator cannot affirmatively testify to what the officer could or couldn't see. Defense says, okay, can we borrow the binoculars? The judge allows them to borrow the binoculars and take them to the scene and says that I expect this will happen within a couple of weeks. Counsel make arrangements. The very next day, a sergeant of the Springfield Police Department contacts the city forester and says, hey, can you trim the trees that are at this very location? The forester does so. After that, after this has been done, the arrangements are made to borrow these binoculars, and in early October, the defense goes there and finds the trees have been changed. Lighting condition is different. They cannot replicate the condition.
But this is 14 months after the drug deal, right?
It is, Your Honor, but as the motion judge points out, these are mature trees. You can see them in the picture. They're 40, 50-year-old trees. These are not saplings. And the judge himself rejects this argument and says the foliage is material to this case. But the conditions are changed. The defense investigator cannot affirmatively say, I stood where Goggins stood, I looked where he said this interaction took place with the very binoculars he had under similar conditions, and he could or could not see what he described.
Wasn't there an opportunity to sort of preserve the scene through photographs so the jury could see for themselves prior to the tree trimming?
The defense fortuitously had gone out as part of this motion and taken some pictures, but they say, the motion judge specifically says, because you don't have the binoculars, you can't, this isn't good enough. You can't replicate what he said he saw. They could replicate what a person without any light enhancement could see, but they can't photographically replicate what the binoculars do. It wasn't good enough for the motion judge, and I suspect it wasn't good enough for the jury because you can't get that affirmative testimony. The trial judge, so we are prejudiced. We can't say that. Yes, we get a jury instruction, but the jury instruction says, well, if you think there was a problem, you may or may not infer it was exculpatory. You're not getting an investigator affirmatively saying, this is what I saw, or replicating it photographically and then being able to cross-examine Goggins and say, look at this photograph. Is this what you could see? We don't get that contract.
Did the jury get the binoculars?
I believe they were an exhibit, but again, they're inside a jury room. They can't replicate the low light conditions. I mean, yes, they could get a sense jury room, but it's different.
But they could get a sense of what those binoculars were capable of doing.
Not, Your Honor, I don't think they can properly test it because they don't have the distance or the lighting. The jury,
but the entire story came out before the jury, right? They understood the significance, right? This was the judge allowed everything to play out before the jury.
The jury was told what had happened. The jury was told what happened. The forester testified, the investigators testified. The problem is that the trial takes place in May, and it takes place inside a courthouse. So the best they can do is turn down the lights. They can't replicate the lighting conditions in the same way our investigator in the field can't replicate the lighting conditions. There's an additional— I
guess what I'm talking about is that the entire, the suspiciousness that the judge, spoke of around the tree trimming and everything, that was all in front of the jury, right? So they had an ability to evaluate what had taken place here and to factor that into their determination.
But what they don't have, Your Honor, is an affirmative statement of how these binoculars would have worked under those conditions. They've got something suspicious that they may or may not find as exculpatory. That's different from affirmative testimony saying, no, he couldn't see what he claimed he saw. Those binoculars aren't that good at that range under those trees. There's also a question that was raised about branches. And if you look at the pictures, they're reproduced in the back of the record appendix, you'll see pre-trimming there are branches. When the investigator takes the pictures, he's been given one location. When, from the Commonwealth, when Goggins testifies, he says, no, that's not where I was in this different location. We can't replicate the pictures from the location Goggins is at and whether those branches are in the way because the tree's been trimmed. In fact, I think that tree is completely gone.
But actually, that's interesting. I noticed the pictures seem to be from a different angle. So are the second set of pictures, the later pictures, after the trimming, is that from the angle that Goggins said he was at?
I believe so, Your Honor.
It's what is our standard of review for this issue? I mean, isn't it abuse of discretion?
I believe so, Your Honor. at least as to the as to whether he was prejudiced, and as to whether this is so egregious that it should be reversed or that it should be dismissed as a matter of policy. And I think this is one of those rare instances where it really should have been reversed. There's a problem here, Your Honors. As the defense points out, if there was a simple, innocent explanation for what happened, the Commonwealth would have provided it. The defense tries to find out what's going on. There's testimony at one point. The trial judge asks, who is this guy Sullivan? Volume 1 at 50. The defense says, we only know his name and rank. We've tried to inquire further and we've done all we can. They're asked about
I'm sorry, wasn't there some evidence about that they'd installed some new cameras and that it needed to be trimmed for that?
That tried to track that down. They're told that the camera was installed sometime in early September. We can't get a critical date. When the defense goes to the property manager calls Springfield Police, who answers but Sergeant Sullivan, and all he can tell them is early September. You'll note that the pictures are taken from the pictures that Sullivan sends to the forester are all street level pictures. We don't have pictures from this camera showing what's blocked. We don't know when the camera went in. We don't have a date. I don't think that necessarily helps the Commonwealth. I think the lack of specificity, I don't think it helps them. We got the information we were able to get because the city forester responds to the FOIA request and is willing to testify. But the defense mentions, again, in that hearing at volume 1, that they are trying to get information from the police department and they're being railroaded, they're being stymied. And I think, again, that speaks to the question of, is this egregious? Should this have been dismissed? And I think this is the rare case where it should be, Your Honors. If there are no further questions, I would rest on the briefs for the remainder of the argument.
Being none, thank you very much. We'll hear from Attorney Payne.
You're on mute.
Sorry, no, sorry. Let's unmute and start again. No problem. We haven't. Your time hasn't started yet. We still can't hear you.
Is it clerk? Yeah.
I'm sorry.
No problem at all.
Please the court. Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the defendant's conviction. In the light most favorable to the Commonwealth, a rational finder could find the essential elements of the charged offense beyond a reasonable doubt. Here, we have a police officer with extensive training and experience related to narcotics investigations. The police officer sees an exchange. He can't tell what the items are, but he sees that an item is transferred. This is an area known for a high volume of drug activity. And most importantly, the drugs are recovered from the buyer, from Mr. Strange, and money is recovered from the defendant. And
there was no connection made that the amount of money correlated in any way to the drugs, was there? I mean, that's typically what we see in these cases to match up the transaction.
Yes, that is true. There was no testimony as to what the street value of the crack that was found on Mr. Strange, what it was.
So it could have just easily been two people who meet. One person has cocaine on them and one person has money on them. But because they meet, we assume that there was some sort of a transaction.
Well, it's more than that. It's because the police officer, again, with much experience, sees a transfer of items. He's seen two similar actions previously, although he was not able to see if an item had been transferred. And I believe that
he saw the defendant meet with two women.
Right, and there was some sort of hand gestures with those two women, but the police officer.
I talk with my hands too. Hand gestures.
Hand gestures with each other in such that their hands touched. But again, the police officer testified that he could not see anything was transferred, and he made that very, very clear. But with the instance with Mr. Strange, he in fact was able to see that items were transferred, and the inference that the defendant sold
the drugs need only be reasonable and possible. The Commonwealth does not have to disprove every theory. And clearly the jury found this based on Officer Goggins' training experience, based on the fact that money was recovered from the defendant, based on the fact that drugs were recovered from Mr. Strange.
I mean, what about the two facts? One, that the rock of crack ends up in a black and yellow case, where yet nobody saw him put it into a case, and that there's not that much time for that. And also the fact that there's no evidence that it's packaged. It sounds like, there's the only evidence on the record that I saw is that there was a rock of crack in the glasses case. I would assume that if you're selling drugs, you wouldn't take an unpackaged rock and just hand it to the other guy.
Well, there had been testimony of at one point that the defendant was manipulating a plastic bag, although that was not clarified in regards to Mr. Strange. But I would suggest that sufficient time had gone by in such that Mr. Strange could have easily put it inside this cigarette case. Officer Johnson's testimony on volume 3, page 69. So Goggins directs Johnson and his partner to stop a heavyset individual, Mr. Strange, who's coming up Lake Street. Johnson, on page 72, he's one street over. The distance between the intersection, not where the exchange happened, but the intersection between Fort Pleasant and Blake, and from where Strange is actually stopped, is, I believe Johnson testified, was 30 to 40 yards. But Johnson also testified that although this is a short street, he has to crest a hill before he goes down and he sees. So I would suggest that there was a small window of time in which Mr. Strange easily could have put this rock of crack cocaine. Certainly,
wasn't the time testimony 30 seconds?
The time testimony was 30 seconds. Actually, I don't think it was very clear. I think there was definitely testimony that there was 30 seconds, but in 30 seconds from by the time Officer Goggins gave out the description, I know that Officer Johnson testified that after he crested the hill, he saw Mr. Strange right away. So I would suggest that there was certainly a window in which Mr. Strange could have put that in the cigarette case, and the Commonwealth recognizes that the record's not quite as clean as we would have liked.
Is there any testimony about Mr. Strange reaching into the pocket where the cocaine was later found?
No, there's no testimony as to that.
And correct, there's no testimony as to it being packaged.
Correct. It's just loose in that cigarette case. But again, I would argue that based on Goggins' testimony of these are fast transactions. I don't strike that. If the panel has no further questions on this issue, I will move to the second.
I just want to, do you agree that there was that in the light most favorable to the Commonwealth, the defendant had been in the apartment building for 5 minutes before coming back out?
I believe that the testimony is 5 minutes. He certainly was out of Goggins' sight for a few minutes. So I would agree with that. In regards to the second issue, certainly the Commonwealth does not condone any kind of misconduct, but misconduct is not what we have here. The timing of the tree trimming request was terrible, and it's understandable that the motion judge was troubled by the timing. However, the motion judge did not abuse his discretion in denying the defendant's motion to dismiss, nor was it an error. Here, the judge found that the defendant met his burden, and the Commonwealth would quibble with that. And I think certainly we could have argued that it would not have been abuse of his discretion if he had found the defendant had not met his burden. But in any event, he found the defendant met his burden, that access to the unaltered trees could have produced evidence favorable to him. But he conducted the requisite balancing test and found that the defendant did not suffer any prejudice based on the photographs. Yet, although there was no prejudice, the motion judge still crafted a remedy that actually put the defendant in a better position to be able to argue, look, here, not only can I argue that Officer Goggins couldn't have seen what he saw, here, look, based the day after the motion to suppress, these terrible Springfield police officers, what do? They call the forester and they have it cut down. I would suggest that the motion judge did not abuse his discretion. There was no prejudice. And even if this court were to determine that there was some prejudice, the trial judge's instruction, the spoliation instruction, certainly alleviated any prejudice. If the panel has no further questions, the Commonwealth would rest on its brief.
Is it true, on the issue about the reason for the request? I believe the reason for the request that was put forward, the request for the tree trimming, was that it was interfering with some cameras.
Right.
So, okay. And the Commonwealth didn't come forward with any information about those cameras, where they were, when they were put in specifically before, the cameras were, sounds like the cameras were suspiciously put in just around the same time as this motion.
It does seem like the cameras were put in sometime in September. I would know in the motion to dismiss transcript, the forester does testify that he had other trimmings and removals along Fort Pleasant, that day, or around that specific time frame. And I would also point out that the investigator did not reach out to the police department to try to coordinate the binoculars until the end of September. The timing, there's no question that the timing is really terrible here, that it occurred the day after. But again, as the motion judge found, it was not an abuse of discretion for the motion judge to deny the defendant's motion. The motion judge did not find misconduct, never mind egregious misconduct.
So the evidence about the reason for cutting the trees being interference with the camera, that testimony came in at the motion to dismiss.
Correct.
Did it come in at trial, or was it stricken as hearsay?
It was stricken as hearsay, and properly so, because it was in fact hearsay. At one point, the trial judge became a little upset. The trial judge was also the motion to dismiss judge, and I don't know if he thought more about it, but he almost like it seemed he had forgotten what had happened at the motion to dismiss, that there had been testimony from the forester that the reason this all happened in the first place, that was the reason on the record, was because they were interfering with some cameras. And then because there was a hearsay objection, he did in fact testify. And of course, once he went there and he saw that there was rot, he did have to remove one tree. That was his testimony.
Was there any evidence about how extensive the rot would have been at the time of the drug deal? Or if it got worse in the 14 months?
No, there was no testimony as to that.
But the trees still had leaves on them as of September of 2018. So
yes, in fact, it was, I believe the forester's testimony had been that originally he had just taken a quick look and everything seemed fine, was just going to trim a few branches, and his crew alerted him to, hey, there's significant decay. We need to remove this.
Did the forester testify at trial?
Yes, the forester testified at
Okay.
trial.
Did Sullivan testify either at the motion to suppress or at trial?
No, he did not.
Motion to dismiss.
He did not testify at all. Unless there are further questions, the Commonwealth would rest on its brief.
Okay, great. Seeing none, thank you both again very much for your arguments. Very interesting.
All right, we are now live and recording.
Thank you. Good morning and welcome to the Massachusetts Appeals Court oral argument session for October 22, 2020. As you know, this argument is being held on Zoom and being live streamed on YouTube at the same time on the Appeals Court YouTube channel. Nonetheless, we'll follow the same rules and customs as in the courtroom, except you do not have to stand when you're speaking. We have granted additional time in this case for the attorneys, and you all know what that is. But there's no rebuttal, and so only one attorney will speak at a time. And when it's not your turn to speak, the clerk will mute you. However, when it is your turn to speak, you're going to have to unmute yourself. Okay. But we do want you to stay on the video when you're not speaking. But remember that we can see you, so please keep your head noddings or shakings to a minimum. As you know, this is being available to the public. It's going to be recorded and archived, so it will remain available to the public. It's an impounded case, though, so we will not speak about anybody's names. We'll speak in terms of mother, father, grandparent, child, etc. And as always, then, we've read your briefs. We're familiar with the case. So usually what I say is you have 15 minutes. You don't have to use it all. I have a feeling that this is going to go by pretty quickly. For those who are watching on YouTube, especially the counsel in the next case, we've granted extra time in this argument, and it will be taking a brief recess after. So the next case probably won't begin for about another hour. And with that, Attorney Chayette.
Thank you very much. May it please the court, Kara Chayette for the mother.
I'm sorry, stop. Can you stop the clock? Is that possible? Let's restart the clock, because I didn't call the case, which is 2020 P4, which we have is in the matter of a child. I apologize. Start again.
Thank you very much, Your Honor. May it please the court, Kara Chayette for the mother. Being slapped or restrained, having your phone taken, having the door blocked when you're in the middle of a vicious argument, these are things that happen in unhealthy relationships. Mother testified to as much, and I'm not here to suggest otherwise. The question is whether this is sufficient to find a parent unfit and to impose what is effectively the civil death penalty, that is, the stripping a mother of her right to even call herself a mother. Chapter 119 has no standards for evaluating the nature or severity of domestic violence sufficient to find a parent unfit. And I would remind the court that that means that the parent is unable to provide even minimally adequate care to the child, and that whatever deficit the parent has places the child at grievous risk. So where do you look? You can look to DCF policies, and I actually filed a 16L letter yesterday with an attachment to DCF's policies. You can look to DCF regulations, which I cited in my brief. You can look to 209A cases like Simboski, which I also mentioned in my letter yesterday, which involved this kind of abuse or violence against a child by a parent. And then you can look at what makes up the bulk of my brief, which is the probate cases involving dueling custodians. And the kind of violence in those cases that nevertheless permitted the perpetrator of the violence to remain or be the sole legal and physical custodian of their child. The violence that's sufficient to wreak the consequences that happened here, it's got to be more than that. And I've asked the court to test the sufficiency of the evidence. And the court has to look beyond the characterizations of what the violence was to see actually what's there. The disparity in standards and consequences is just too great.
Well, can I ask you, I think it's an intriguing argument, but the one thing that comes to my mind is that in those cases, the custody battle cases, you're talking one parent against the other. In these cases, actually domestic violence by either parent and the other parent's inability to face it or get out of it can be used as a factor. So even it's right. So it's not. Here the mother's getting blamed. The father's not being taken. It's the right. You see what I'm saying?
I think so. Although I actually, if we can sort of hold that up in the probate court cases. So you're saying, of course, I don't know. I think that in several of the cases, there is she did this, but he did that. But even stripping that away, in those cases, even it's more often the father or the husband, even in those cases where the husband was the perpetrator, he's the one that gets the kids. And so in fact, it proves the point, I think, more than it detracts from the point. And again, in a certain way, with all due respect, I think your question begs the very question. Until the state can say, you're unfit because you won't separate from this man, doesn't the nature of the relationship have to be assessed? Otherwise, and I apologize, my mind goes to always in these arguments to metaphors, but there's something sort of re-education camp about it. Unless you adopt our view of your relationship, unless you adopt our language that we're applying to your relationship, you're unfit. And as happened here, if you then adopt the language that we want to hear, and if you commit to separating, well, it's too little too late. And if anything, you've just confessed to the crime that we were accusing you of in the first place. So in this case, there are a couple of findings that I was noting as I was preparing for argument, that the judge ruled that one indicia of mother's unfitness was that she lacked insight about the verbal abuse because she wouldn't describe it as verbal abuse. She described it as verbally negative or verbally confrontational, no insight, ergo unfit. That's finding 78. But mother did use that language. She described it at transcript 685, 775, 782, 1190, and 1397 as verbally abusive. And many of those transcript sites are from before October 19th. If you'll note that I think it was finding 84, where the judge claims that mother did this 180 on October 19th, and suddenly she was embracing the language and the allegations of the department, and she found it not credible. So there's sort of you can't win for losing, heads I win, tails you lose. And again, there was good and there was bad. Fit parents have the autonomy to do the cost benefit analysis and say, there are these things that are unhealthy, and there are these things that are healthy. She actually testified at 775 about having worked with a domestic violence counselor and she said that 60% of the things on this is what a healthy relationship looks like, she could point to 60% of those, but 80% of the unhealthy relationship items she picked. She did a cost benefit analysis and it hurt her, but she still loved this man who had reasons to be loved. Even Ms. Hubin, who oversaw some visitation, she was an expert who was brought in to supervise visitation. She was provided a glowing assessment of dad's capacity as a dad. It wasn't only mother who saw the dad's strengths, even though those were all sort of stripped out of the findings. And I see the clock goes so fast at oral argument. You prepare so hard and you wonder what you'll say, and then the time starts to slip away. I'm happy to answer. Obviously, a big part of my brief is on the domestic violence issue. Excuse me, but I do want to say something about the substance use issue as well. Justice Massing, did you have a question?
No, because there's not just violence. There's substance abuse and there's mental health.
Right. So The judge found one of the big issues was mother's substance use while she was pregnant. And so at finding 123, 141, 151, the judge says the mother lacked insight into the effects of her on the baby of her in utero substance use and characterized it as child neglect. So this is mostly what she used: Klonopin, Xanax. She used intermittently while she was pregnant. After she discovered that she was pregnant, she was prescribed those drugs as a childbearing age woman. Any woman of childbearing age who is prescribed these drugs will be using them for some period of time during pregnancy. And different women discover that they're pregnant, whether because they're in denial or their bodies. In this case, mom had a medical condition that she thought prevented her from getting pregnant. She didn't know till she was 4 months. So the baby was exposed to those drugs for 4 months. And again, these are common facts. Unless we're prepared to say that women of childbearing age can't be prescribed them, how does that become evidence of her unfitness? And she smoked marijuana. I included a Boston Globe article in my brief. If clinicians can't agree about the cost-benefit analysis of preventing nausea and making sure that a woman is gaining weight, and whatever quite unknown risk there might be to a fetus from smoking marijuana, again, how do these things add up? And in terms of her mental health, we're not going to deny she was so bared her soul about her challenges. But I have to say, I think a lot when I'm dealing with these cases. What if they were tried before juries? I mean, or if we were actually in Boston in a courtroom and had people, if you ask for a show of hands of how many people have suffered mental health, how many people have thought about suicide, do we take those children away? How many people as parents smoked marijuana or were prescribed these drugs? Such relatable facts, and including on the domestic violence side, shouldn't be enough to be able to render somebody unfit and to terminate for forever their parental rights. And so with that, unless there are any questions, I'm running out my clock, and I will just rest the rest away on my brief.
No questions? No further questions? Okay, thank you very much.
Thank you.
And so now, Attorney Como, I think you have to unmute yourself. And
thank you, Your Honor.
Here we go. But you have 5 minutes for the father.
That's correct, Your Honor. May it please the court, I am William Como. I represent the appellant father. The juvenile court committed reversible error when it excluded the guardianship petitioners who were father's best interest plan from the 3rd through 12th days of trial. During days 3 through 6, they were each referred to over 500 times, much of which was harmful to the father's best interest plan. It was a doubtful proposition that the court could use testimony against the grandparents' guardianship that was taken during a separate proceeding from which they were excluded. Their exclusion and the inability of the father to consult with them about any of the damning testimony severely impacted his best interest argument.
So, why does the father even have the standing to raise the grandparents' presence?
Well, because they were his best interest argument at the trial, and so any parent, any party has the right to present their own plan for the child should they be found unfit. In this case, that plan that the father presented was his parents to become guardians of the child. So he certainly had standing to present that argument and to argue.
But then, actually, wasn't the thing that actually triggered the ordering the parents out of the classes that the grandparents out is that grandfather appeared to be coaching father during his testimony, with nodding and shaking and indicating yes and no?
No, I think that I disagree, Your Honor. And certainly there may be something in there about that, but I don't recall more than once that the grandfather was spoken to by the court. And the discussion at sidebar certainly didn't include that. The discussion at sidebar included all the reasons why they thought that the grandfather should be excluded. And most of the discussion had to do with 11929D. They didn't mention it, but they presented that because he wasn't a foster parent, he was only a third-party custodian, that he didn't have any standing to be in the court. And so clearly 11929D is actually the complete opposite of that, that a third-party custodian has every right, as much or probably more than a foster parent, to be in the court, to attend and to be heard. So I certainly there may have been a little bit of that that addressed that in the judge's findings, but that wasn't the discussion. That wasn't the basis that she presented at the hearing. And my estimation, it was an afterthought to throw in there to support her weak argument for the exclusion of the grandfather. Each of the court's reasons lacked merit. I've already discussed 29D. But the other issue was that the judge suggested that, well, this is a best interest hearing issue, and so I'm going to present the grandparents, let them present their case at the best interest hearing. Unfortunately, what happened immediately after their exclusion was that the DCF attorney began questioning the mother, the aunt, and then the social worker for 4 days about the grandparents. The focus of the testimony was about the grandparents. It's basic to due process that a litigant has a fair opportunity to rebut adverse allegations. The court in Phelan reversed on much less than this. In Phelan,
Well, does 29D give the grandparents the status as a litigant or the right to cross-examine witnesses?
no, it does not. It does not. No, they only have the right to be in the courtroom. And that's all I was arguing on that issue. But there are other reasons why they had the right to be in the courtroom, in addition to 29D, and to participate.
Could the judge in her discretion have decided that it would enhance the truth-seeking function of the trial for the grandparents to be excluded and therefore other witnesses would be more forthcoming?
She certainly had the right to do that if there was sufficient evidence for that presented, likely through a motion, which wasn't done. This was a sua sponte request by the DCF attorney. And at that sidebar, and that's right around the transcript 500 through 608, 599 through 608, the discussion really is that the reason that she brought the motion was she was concerned that the mother might have a difficult time. She might be uncomfortable testifying in front of the grandfather. Well, that's not a basis for excluding anybody from a trial. And in fact, the mother's discomfort may be because she didn't want to be caught lying to the court, and the grandfather would know that she was lying. So we don't know, without more information than the court had, that was a sufficient reason to exclude. I see my time is up, and it does fly. So.
Any other questions, Justice Singh or Grant? Okay, thank you, Attorney Como. Next, it's Attorney Don, also 5 minutes for the grandparents.
Good morning, Your Honors. May it please the court, my name is Andrew Don, and I'm appearing on behalf of the paternal grandparents who are guardianship petitioners, and we're also third-party custodians of this child for 15 months of this child's life and through the full duration of the trial. And we're requesting that this court vacate the juvenile court dismissal of the guardianship petition, remand the matter back before a different judge than heard this matter. And we're also asking this court to return custody of the child to the grandparents immediately, as it was error to remove him in the first place, and there was never any evidence that this child was mistreated in the care and custody of the grandparents.
Could you answer the question that Attorney Grant asked Attorney Como, which is, doesn't it further the fact-finding function to sequester the witnesses and have them each testify without the presence of others?
It's theoretically possible that that's the case. However, what the judge forgot is that these grandparents are guardianship petitioners and therefore are parties to the litigation. They're not just
Oh, they're parties to the, I mean, she didn't forget that. She said, you're parties to the guardianship. I'll let you for that, but you're not parties to the determination of permanent rights part.
Correct. But the way that the trial was actually conducted under either theory was so fundamentally unfair to the grandparents that it has to be vacated. So what do I mean by that? Either we take the judge at her word and that she did in fact try these cases separately, that there was the best interest trial, and then at the end she included the grandparents. However, she admitted in her findings and in fact all of the exhibits entered in during the parents' trial against the grandparents, and she admitted findings that were from the evidence that was gathered during the parents' trial against the grandparents. That's structural error, Your Honor. Also, introducing information from a separate proceeding, which is conceptually how the judge was setting this up, is explicitly prohibited by adoption of Zeta, as I referred to in my brief. But that's black letter law. But
are these really separate proceedings? There's two parts of one proceeding. Are there two parts of one proceeding?
Right, so that either the judge had to allow the grandparents to be part of the whole proceeding as guardianship petitioners, or not enter all the evidence from it against them. She can't have it both ways, and she blended these in a way that was fundamentally unfair and led to the grandparents neither knowing the evidence that was entered against them, having any ability to know who the witnesses that and what they said testified against them, and also had no idea about the exhibits and had no opportunity to cross-examine any of this. That all results in fundamentally unreliable findings and conclusions.
Let me ask you, can I interrupt you? Didn't the judge give the counsel for the grandparents the ability to be in the courtroom for that?
She did permit him to, but she also then prohibited any of the parties from communicating with the grandparents about what was happening in the trial. So that you have a circumstance where counsel...
Did she prevent the attorney from communicating with the grandparents?
Well, there's no communication about what's happening. So when there was, and why that's important is this, is that the attorney was told that the judge would be trying these proceedings separately. So he had no reason to think that all the information that was happening on these days would be about the grandparents. He took the judge at her word that the grandparents would only be considered at the very end of the last couple of days of this trial. He relied on the judge's representation about how she was going to conduct this trial. And then the trial was in fact conducted entirely different than that. He had no reason to believe that this was going to happen, and he had no reason to be on notice about it and therefore didn't object. And I think that's really evident in the kinds of questions that grandparents' attorney actually asks, as you can see in the transcript there. He just asks about their home, about their care of the child. He doesn't address any of these allegations that came in against the grandparents because he had no idea.
So he had an opportunity to be present, but he wasn't there because thinking that it wasn't going to involve his clients.
Exactly. He relied on what the judge said was going to happen, but did not in fact happen. And as Justice Singh said, that these were not separate proceedings, despite the representation. And it was fundamentally unfair, deprived the grandparents of their right to the trial.
You have to leave it at that.
Thank you very much. I apologize.
No problem. Any other questions? Okay. Well, on this side, we'll hear from Attorney Levin for the child.
Thank you, Your Honor, and may it please the court. I do represent the child in this matter, and the child's position through substituted judgment is to remain with the grandparents who raised him between the critical ages of 6 months and 20 months, whom he sees as the parents and who provided for him without fault during that time. The child asks this court also to vacate the juvenile court's best interest determination, its dismissal of the guardianship petition, to vacate its order terminating the third-party custody to the grandparents, and also to remand the matter to a different judge. All reports were that my client thrived at the grandparents' home, had a strong, significant bond with them, and yet the judgment of the trial court directly led to his removal from that home, and it approved instead a recruitment plan by the department that really wasn't a plan at all for its lack of detail. And so I want to discuss during my time the problems with the adoption plan. No case law states that no plan is acceptable. This has been before this court on numerous occasions. Adoption of Thea, Hugo, Stuart, Varick more recently, and Dora, and numerous others. And there needs to be a plan that identifies characteristics of a prospective family and their home environment that addresses the particular needs of a child. There's no question that that was not done here. The department was allowed to submit a recruitment plan. They admitted through the adoption social worker's testimony that that plan was going to be developed in the future once they had custody and were able to put that together.
Is there anything in the record about what's been happening since this appeal has been pending?
In the record, no, not to my knowledge, Your Honor. So there was no information, for example, in the plan as there was in adoption of Stuart or adoption of Varick. Does this child need a one-parent home, a two-parent home? Does he require a less chaotic home and therefore such that he would be the only child? Or would it be better that he be placed with other children? Would he be better in a home where he's the youngest or the oldest? What supports might be necessary to help him in his transition from the grandparents' home?
How do you respond to the DCF's argument that they couldn't have that type of detailed plan because they didn't have the child in custody?
Your Honor, I don't think that that's factually correct. It is true that they didn't have him in his custody, but that didn't prevent them from developing this for several reasons. And I think the record supports it. The department did have custody of him from the ages of 1 to 6 months. And once placed in the third-party custody of the grandparents had signed a release for all the child's collateral. So the department was able to stay in touch that way. And as well, the department was constantly in touch with the grandparents. They were in and out of the home. They were checking in. They didn't simply go away. So they had a good handle on this child's situation. The court recognized that transition from the grandparents would be difficult for this child, but there was nothing in the plan to address that difficulty. And in fact, the adoption social worker testified that the department had not considered or discussed the harm being inflicted on him from that removal. In adoption of Dora, I would note an adequate recruitment plan was required to define in some detail, the court said, the characteristics of the home which is being sought for the child. And in Varick more recently, this court remanded when...
Right, I'm going to interrupt you. The judge was obviously aware of Varick because she cited it in a footnote that some of the parties object to. And the judge, it seems, was aware of this argument. She compared the relatively sketched out plan the DCF had for adoption to the other option, which was keeping him with the grandparents. And the judge, in her or his view, clearly preferred the less detailed plan to what to the devil she knew.
Yes, she did, but that's error. The judge's attempt to distinguish Varick in particular was problematic. She accepted the bare bones recruitment plan on the basis that this child, unlike the child in Varick, she said, didn't have special needs. And that's a problem because the common law developed over a great deal of time in this court has not made that kind of distinction. every child, regardless of their needs, requires a recruitment plan that has the kind of detail that our case law, such as I just described to you through adoption of DORA, has always required. And there's no get out of jail free card because the child doesn't have identified special needs. I think the judge here tried to fill in the missing pieces. You'll find perhaps at finding 413 by citing to a DCF permanency plan that filled in some of those gaps. But the problem is that permanency plan isn't in evidence here.
Okay. Well, unless there are any questions from my colleagues, we'll have to stop there. Okay. So we've heard from all of the council who are in favor of reversing the determination one way or the other. Now we'll hear from DCF. I see he's trying to unmute himself. There we go.
Have I succeeded?
You have.
Okay, thank you. May it please the court, Brian Parisa for the Department of Children and Families. I guess I will begin if the court doesn't have a preference, I'll begin where the child was left off, and that is with regard to the department's permanent plan for the child. My brother is correct that the department needs to present a plan, and that plan needs to have something about an individual child. Nobody is saying that children are interchangeable. No one is saying that every child is not unique. But the fact is that this judge did consider what was unique about this child for the purposes of the plan. So, if I may, the age of the child was considered, that the child was still less than 2 years old, was a toddler, and the consideration findings were made that the child would not have difficulty transitioning to another home. So the factor of transition was. Moreover, the court specifically found that the bond with the grandparents was a factor and added in finding 411 that the child would need to have ongoing contact with the grandparents. So provided for something that would ease that transition, recognizing that. So the court did consider the particular circumstances of this child with regard to the transition. With regard to a home that was being sought, of course, the fact that the age of the child and those special needs of the child, just as a matter of fact, gave the department a much broader net to search for an appropriate home. The fact is that for a child of this age who's not going to have substantial difficulty bonding to a new family, who has no special needs, it is simply going to be easier to find, and the available appropriate families are going to be more in number than children who have other factors that would target them towards a particular family. So these factors were all considered in addition to the fact that the department did not have custody and could not find a particular family. The court considered the fact that the department was going to do a family find. So the court was aware, in addition to a normal recruitment plan, that the department was going to be seeking a relative first before proceeding to unrelated recruitment options. So there is much more here than the appellants would have you believe with regard to the specifics of the plan. That, in addition to what was noted, is that really the court considered the only three options that were presented to the court and available to the court. The parents were determined not to be an option because of their unfitness. The grandparents were determined not to be an appropriate option because of the court's findings that they were not suitable guardians, and continued placement of the child with them would not be in their best interest. And therefore, recruitment with these considerations in place was in fact the plan that was best for the child.
So can we going backwards then? The evidence seems to be that the child was thriving with the grandparents. And it seemed this, I've seen a lot of these cases over the years now, as I know you have too. It seemed rather strange to remove a child who was doing well from a situation where he was doing well.
Well, I agree with you. It was not what is seen in many cases. And the trial judge obviously wrestled with this problem. When you read the transcript, you see, of course, that not only was third-party custody given to the grandparents after a few months of the case pending, but problems developed, or at least I should say problems that the trial court believed to be problems developed. In the middle of the trial, there are discussions about visitation, difficulties with visitation, and where it's taking place, and the grandparent situation. Restrictions are put on visitation. Nonetheless, despite requests to the contrary, the trial court believes that because the child loves his grandparents and because the child is well cared for there, it is in the child's best interest to remain there pending the trial. This is not a judge who merely overlooked and completely disregarded the grandparents' role in this child's life. The trial judge wrestled with what was best, left the child there only until the trial was complete. And at that point, you are right, the trial court did not fault the grandparents for the day-to-day care that was provided to the child, but merely said over the long run into the future, these grandparents could not ensure the child's safety given the danger that their son presented to the child. And that is what this case turned on. Was the trial judge.
Usually it's usually these cases passed as prologue. It's the bad treatment of the child. There's no indication that it's going to stop. She's saying there's good treatment of the child, but but I think it's going to stop.
Well, she doesn't say actually that the good treatment that you're referring to, Your Honor, is going to stop. I imagine that the trial judge would agree that the child was still going to be fed, clothed, educated, cared for, and loved in an appropriate manner. The trial judge doesn't dispute that. What the trial judge does dispute is the past is prologue. The trial judge finds that the grandparents have a lengthy history of enabling their son, of overlooking his defects and his abusive behavior, okay, and of accommodating, of being enmeshed with him, and enmeshed with him to the point that they would not be able to break free of that. Now, it is possible the trial judge believed that the grandparents might be able to contain that under the watchful eye of the department and the court, but clearly she had no confidence that situation was going to remain in effect throughout this young person's childhood, while outside influences were not ensuring his safety. And that is where I agree that the court did consider past as prologue and considered that relationship and considered and made express findings that enmeshment, and she referred to it as an enmeshment, the trial judge, was going to continue into the future and boded ill for this child's long-term safety in that home. Please remember, this is not an unfitness standard. The grandparents don't need to be found unfit. The only question is a best interest standard. And the trial judge clearly found a lot in the grandparents to merit and a lot in the grandparents to laud, but merely weighed that against these other factors. That is her function. That is her job. That is her discretion, and found that in the long term, placement in another situation with ongoing relationship with the grandparents, obviously, that would be in the child's best interest.
What do you say to the argument that because the grandparents were excluded from the courtroom, they missed out on hearing some of the evidence that would have that led the judge to believe that they were enmeshed with the son, the father, and the mother in unhealthy ways, and that basically set the grandparents up to fail that exclusion?
Well, I would say, in addition to what I cite in the brief, the fact that the counsel for the grandparents was not restrained in any way in calling witnesses or recalling witnesses. Counsel for the grandparents did not object to being kept out of the room after he had assumed representation of the grandparents, was told directly by the judge into how the matter was going to proceed, and made no objections, raised no questions about what witnesses were not going to be there, never raised an objection to the manner of proceeding as long as he had filed an appearance. So ultimately, at the end of the day,
isn't that partly because there was a misunderstanding of what was going on? The judge, there's nothing here that that concerns you, and he took.
No. What I'm saying is that I find it difficult to believe, given even the cross-examination of the grandparents and the evidence that arose during the portion that he was present for and the grandparents testified for. I find it hard to believe that counsel did not consider the fact that that one factor in assessing the grandparents' suitability as guardians would be their ability to protect this child from their son. They knew that their son was facing a termination of parental rights. They knew that their son was facing that because of domestic violence, not only with this woman, but a history with 2 previous women that are in the findings. They were aware, they were around. They were part of those facts that happened, even if they weren't in the courtroom. They were aware that there were issues with the mother and they were supervising visits, and they were enabling, as the findings show, the mother to spend time with the father during visits instead of the child. They were aware of their treatment of their son being a factor. I find it very difficult to believe that counsel would not have thought of that was a relevant factor, just judging by his and his client's exposure to this trial and the family in real life, that it would not have occurred to him that there might have been some other witnesses that he might have called with regard to that, or that he could have structured his direct examination differently or his redirect examination differently. I mean, that there was full access to that material.
So there's the grandparents' brief has many pages going over the facts that came in when that they didn't have a chance to contest or they weren't present for. Is your response to that's their own fault?
No, I think the judge had adequate reason to remove them, to sequester them from the hearing for those periods of times. The grandparents are not parties. And even though they may have had temporary custody of this child, that fact did not render them parties to the care and protection proceeding. It didn't under the statute, and it didn't under the Constitution. They had no right.
To be present, though, right?
I'm sorry?
But they did have a right to be present.
They had a right, and the department discusses this with reference to this court's decision adoption of Sherry. They have a right to be heard on the disposition of the child. That's what 29D says. They have a right to be heard on the disposition. And that is largely, and I quote at length from the Sherry decision, that is largely to assist the fact finder in determining what's best for the child.
Does the 29D right to attend the hearing mean to attend the entire hearing or just to attend part of it?
Well, it does not say either. It merely says to be present and be heard. And I would submit that a trial judge who has legitimate documented concerns that would support her decision to sequester the witnesses and support any undue influence that they may have over the mother's testimony and the accuracy of her testimony, that these legitimate concerns permit the trial judge to remove remember, a lot of talk has been made about due process here. And I just remind this court that there is no confrontation. Parents don't have a confrontation right in these proceedings, let alone grandparents, temporary third-party custodians. There is no right to confrontation, okay, to be present in this room. We have decisions upholding the removal of parents from the courtroom when their children testify against them. And that is held to comply with due process. So to remove a grandparent who has temporary custody while the judge is figuring out what is best for this child, to remove this person who has no statutory right to be there, who has no constitutional right to be there, and who presents a legitimate, documented danger to the judge's fact-finding proceeding, this is perfectly legitimate. And they have counsel now who has a chance afterwards to make up for anything that may have been lost. Ultimately, when you look at, I understand it. I agree with the basic principle that a party should have a right to hear the evidence against it. But a party, remember, this is a complicated fused proceeding. And so long as the party has an opportunity to rebut those allegations in some form, it doesn't need to be from hearing them firsthand and cross-examining the witness firsthand, because we know that doesn't always apply to parents, so it can't apply to grandparents. As long as the party has an adequate opportunity to rebut those allegations, then due process is served. These grandparents heard over half of this trial, because remember, before the sequester even happened, they had heard several witnesses testify. And then their counsel was allowed to sit in on other witnesses who were relevant to their guardianship. And then after their guardianship proceeding started, or the guardianship phase of the proceeding started, they were permitted to be there. So when you look at it in totality, they were there for more of the trial than they weren't. And simply, there was no restriction placed on their ability to put on a guardianship case afterwards, to recall witnesses, to call their own witnesses, to present any evidence that they and their counsel felt was relevant. And that didn't happen.
But the judge has heard, and in fact admits exhibits that were that came in with when the grandparents weren't present, though. And how can they rebut stuff that they don't even know what the evidence is?
Well, I suspect that most of the exhibits that are being referred to here are a line of 51A and B documents and department records. Again, there's no indication that these people as the custodian did not have access to those records, that they could not have requested those records from the department, or they couldn't have requested those through discovery on the guardianship petition. So there's simply no reasonable argument that they could not have accessed the department's case file or large portions of it that were relevant to their guardianship proceeding and use that to present their guardianship petition.
Can I ask you about, wait, I don't want to, I'm going to switch to gears to the mother unless the other justices want to ask more about the grandparent part. And I don't know if Attorney Chad was going to regret this or not, but I'm going to ask you about the re-education camp aspect of the domestic violence. So how do you respond to that? Respond to that there's a different standard in the other child custody cases, and that kind of what you're asking the mother to do here is, is to speak out of both sides of her mouth.
Well, of course, there's a different standard in those different child custody cases, because as the court noted when my sister was arguing, divorce or custody cases involving two presumptively fit parents is just that. It's a best interest determination between two presumptively fit parents. State intervention cases have to be proved by a heightened burden of proof. So whatever the degree of domestic violence may have happened in any given case, the fact remains that domestic violence, in addition to any other evidence of parental unfitness, has to satisfy the judge clearly and convincingly that the parent's unfit into the foreseeable future. That's the standard. So to the extent that if the domestic violence standing by itself were, as my sister characterized it, holding someone back, an occasional slap, taking their cell phone, something that she in her brief has characterized as mild domestic violence, if in fact it were that, and that alone, well, I suppose it might be conceivable that a trial judge might find that was not clear and convincing evidence of parental unfitness standing by itself. But that is not what this judge found. This judge found domestic violence that was somewhat more serious than it's characterized in the mother's brief. Remember, there are specific findings made from the mother's testimony about the fear she felt from father's manic behavior, the manic behavior that continued after the child was born, that continued after the child was removed, findings about his manic behavior, his unpredictability, his dangerousness, and the fear she felt from it. That, in addition to even the isolated instances that are described in my sister's brief, involve bruising, involve restraints on liberty, and findings with regarding to verbal abuse. And again, with regard to the re-education camp, I don't think it matters how you phrase that, whether you want to phrase it as verbal abuse or name calling or whatever you want to say. The fact is that the finding was made, no matter how you characterize it, that he called her names and he verbally assaulted her in such a way that it had a distinct effect on her and it made her fearful. Okay, that's the definition of an assault, right? So we have this behavior that is more serious. We have it in the context, by the way, findings that were made of a pattern of behavior, because there were 2 previous women that this father engaged in that the trial judge also added in the guardianship findings. We have this behavior, but that's not it, okay? That in itself might be clear and convincing evidence, but it doesn't need to be, because there was mental illness and there was substance abuse. And, you know, this doesn't get brushed off so lightly. The substance abuse was not a matter of just taking a few prescribed medications during pregnancy. There was also alcohol abuse during pregnancy. There was marijuana abuse during pregnancy. There were unprescribed opiate use. There was screens after the child was born that showed that this behavior continued. There was the mother not being truthful about her use of illicit substances, prescribed, unprescribed, even if they're prescription medication, unprescribed medication, that she wasn't truthful with her therapists about that she wasn't truthful with the department about it, and that evidence that she was self-medicating when she talks about taking this because she can't deal with the stress, okay? So it's a woman, by the way, who is not just taking prescribed medication, as was argued earlier today. It's a woman who's taking non-prescribed medication to treat a condition that may require prescribed medication. And she's choosing to self-medicate, and in such a way that resulted in her nodding off during visits, not being steady on her feet. So when we talk about a nexus, here's a child caring opportunity where the mother is actually under the influence, or at least manifesting behavior that's described as under the influence, that the court could conclude is under the influence of, and which she admitted, by the way, before the visit, that she did take substances, including alcohol, before the visit. It's inhibiting her caretaking of the child. Her mental illness, including many are bipolar and her borderline personality disorder and her post-traumatic stress disorder, is inhibiting, and I cite this in the brief, her ability to face these stressful situations. She acquiesces to the father's demands to have sex during a visit with her child because she doesn't want to say no to him, rather than the allotted time to visit with her child. This is her mental illness impacting her care for the child. This is her substance abuse, which is inextricably linked to her mental illness, impacting her care for the child. And this is her relationship with the father of the child, and domestic violence. This taken together is what is clear and convincing evidence of parental unfitness, not a few isolated instances that in a divorce case might otherwise allow a parent who's not alleged to be unfit achieve custody of a child. If the panel has no further questions, the department is content to rest on its brief.
Seeing none, this is a thank you all. It's an extraordinary argument. I don't think I've ever done this before, this amount of time. A time well spent. So thank you very much.
Thank you.
All right, we are live and recording.
Great. I think it's still good morning, and welcome to the Massachusetts Appeals Court oral argument session for October 22, 2020. As you know, the argument is being held on Zoom and being live streamed simultaneously on the Appeals Court YouTube channel. We will follow the same rules and customs as in the physical courtroom, except that you don't have to be standing for your argument. Once we get going, the clerk will display the countdown clock in the where the insignia is. And each side has 15 minutes to argue, and there's no rebuttal. Only one advocate will speak at a time, and the session clerk will actually mute the person who's not speaking. But we can please stay on the video, and so we can know that you're still there, and know that we can see you. So please keep any reactions to a minimum. As always, we've read your briefs and we're familiar with the case. So although you may feel free to use all 15 minutes, there's no penalty if you stop early. With that, I'll call this case, which is Amanda Harper versus Z2A Enterprises, number 2020 E38, and Attorney Beauregard representing the appellant.
Thank you, Your Honor. It's my honor, if you will, to appear before the court, although in a different fashion than previous years. I represent Mr. Nazraoui, who is a person who has been harmed by the proceedings below. Notably, Your Honors, I have not referred to him as a party because he hasn't been a party. He's been, at best, referred to down below as a non-party. This is a petition for enforcement of an MCAD claim. And I would point out that all the way through the proceedings before the MCAD, which incidentally were the attorneys involved for the defendants in the MCAD claim were other attorneys before. We were into this case more recently over the last several months. But the claim was throughout tried in an atmosphere of default, and that has continued all the way through. And that's the subject of other problems that arise from the case. But in any event, it is a petition for enforcement, which is something that is not your usual lawsuit. If I understand correctly, the petition for enforcement is one whereby it is a simple matter of looking for a court judgment as opposed to an agency that cannot actually issue executions or judgments, but it's a petition in order to reduce the MCAD's findings, some, I think, $80,000 plus when you total all of the damages and fees together into a judgment against the defendants in that case. The defendants in that case are twofold, and I would call them default and defunct, because Z2A is a corporation that existed but was dissolved back in 2017.
Was it dissolved voluntarily or involuntarily?
It was, I believe it was a lack of updating the administrative filings that were required. So it was an involuntary dissolution. It was not conducted by an attorney. The other defendant has been absent, if you will, a gentleman by the name of Abdullah, who was the manager of the premises in question and was taken to task quite emphatically by the hearing officer in the MCAD case that described in some detail the conduct of Mr. Abdullah. What I would then,
I'm sorry to interrupt, but we understand that your client is not a party in the MCAD proceeding, or not a named defendant in this proceeding. However,
That's
he is the former president, secretary, treasurer, sole director, sole member of the now defunct
that is correct. That is absolutely correct.
And owns the property that was the corporation's place of business.
That is correct. He owns the property together with his wife. The deed that was used in the course of the proceedings below was not a current deed. It was it's a property that's owned by himself and his wife. I believe they have a homestead on the property. But what I would point out about the MCAD proceeding, to keep in context, and there's an explicit finding by the commissioner who did the findings in that case that said, and this is on page 21 of the appendix, and I quote her, "The respondent Z2A Enterprises is also vicariously liable for the unlawful actions of its general manager toward complainant." General manager was Abdullah. And then these key words, "notwithstanding that complainant did not complain to the restaurant's owner, Nazraoui." So I think it's significant for context, if not legally, that Mr. Nazraoui was not a party to that proceeding. And clearly it was even was a finding that would have negated any direct liability on his part or any vicarious liability, because he was not the employer. He enjoyed the benefit of corporate protection, which we all know is something that generally businesses avail themselves of. And there is absolutely nothing other than what Your Honor mentioned, which would have been one of the things that one would have to, I would think, establish as part or the beginning of a piercing the corporate veil case, to establish that the person is the total owner, the president, the treasurer. But in and of itself, I submit to the court that there's no case that would be found in the Commonwealth or any other state, I believe, that would say that that's enough to try to establish that there's piercing the corporate veil. Obviously, there are numerous businesses in this Commonwealth whose owner and president uses their home address because they don't need to establish an independent address simply to avail themselves of protection. In this
As a
case,
question,
yes.
I understand that you argue in your brief that Mr. Nasrawi was never served with Harper's petition in the Superior Court. At page, I think it's 128 of the appendix, there's the notice of service of the petition, and it reads that delivering in hand to Sandra Nasrawi, agent, person in charge at the time of service for Z2A Enterprises, Inc., comma, Alex G. Nasrawi, president, and then with an address. Are you saying that that's not sufficient to show service upon Mr. Nasrawi?
Without question, that is my position. If it were effective to bring him into the case, but he's not named as a party in the case. And if they did that, they would be serving somebody simply to put them on actual notice, I suppose, but not to bring them into the case. In order to have somebody in a case, you have to have a claim against them. And in this case, there is a petition for enforcement, which is not a piercing the corporate veil complaint by any measure. And secondly, there's no service against him personally. When one is named in that fashion, I would suggest, and that's a normal way, as I've seen returns over the years, that a sheriff will, constable will indicate on the return the names of the person that they have brought in, that they have notified. In this case, it would be his wife. And it's not even clear here that the service was to Nasrawi, Mr. Nasrawi. It says by delivering in hand to Sandra, and then it goes on to list in what capacity they're doing that. It says agent, person in charge at the time of service for Z2A Inc., comma, Alex G. Nasrawi.
But that address is where they both live.
It is.
And then Mr. Nasrawi moved to dismiss in 2018 and again in 2019.
As a non-party. He moved to dismiss the attachments. There were attachments that were filed against his property. And it is clear to me from the record that Mr. Donovan has maneuvered, and I don't say that to detract from him, but he has maneuvered the names of the parties that are here and the parties that are served. When you find attachments against Z2A or against the other fellow, Abdullah, there would be every reason in the world to issue real estate attachments against Z2A or against Mr. Abdullah, because they're the people that it looks like there's going to be a very steep uphill climb to avoid liability in a petition for enforcement case. That is altogether different than a claim and a burden on people that bring lawsuits against other people, in this case against Nasrawi, to establish something that is a steep climb to liability on a piercing the corporate veil case. In this case,
sorry,
Judge,
I'm going to interrupt you again. Sorry, because
yes.
on this procedural issue, you are appealing from the denial of a motion to dissolve an attachment, right?
Right, that is correct.
And you filed that motion twice. And one was an emergency.
Actually, 3 times, I believe. Yeah.
Okay. The first time it was denied was on August 1st, 2018, and you did not appeal from that.
Correct.
Then you filed it again 8 months later. How can you revive an appeal you missed by just filing the identical motion again?
Well, first of all, it's predecessor counsel, so that I don't take too much blame insofar as any.
Well, but your client is stuck with that.
My client, and I understand I have to defend that proposition. There is no final judgment in the case at that time, Your Honor. It's an interlocutory ruling against someone who A, is not a party, and B, there is no claim to support it.
There's
There is
still
no,
no, and that's true. That's true. There's still no final judgment.
there is now, Judge, in the Superior Court case, judgment entered, and it's a matter on the docket. The case is over against both Mr. Abdullah and against Z2A. It's all over and done, and it's been over and done for a while. My client ends up in purgatory. It's been pointed out by one of my colleagues here, because they're in a non-place, they're a non-party, yet they are suffering the problem and the detriment of an attachment that appears to be, that is on the record in the registry, which is preventing refinancing of his property that has cost him thousands and thousands of dollars, but there's no effective way that he can get out of the case. My first dilemma in this case was, what am I going to tell the judges on the appeals court when I stand before them or sit before them and tell them I feel kind of silly because I'm not representing a party to the case. I'm representing a non-party. And I suppose that's something that not only I have to wrestle with, but truthfully that the appeals court may have to wrestle with as well. The problem is that I am nowhere, or my client is nowhere, except in a detriment that they will never have the ability to get past the real estate attachment, because there's no vehicle for it. If somebody suggested to me that, well, why didn't he intervene? Because there is an intervention on Rule 24 that's available to litigants in cases or non-parties. And my answer after reading Rule 24 was that we would probably have technically no standing to intervene in a petition for enforcement against two parties for whom we are not responsible. We simply are not responsible unless and until a piercing the corporate veil case is made, but not only made, but it has to be claimed. And it's never been claimed, except 2 or 3 months ago, it was claimed by Mr. Donovan in an independent Superior Court suit. I would like to draw the court's judicial notice attention to Bristol County 2073 CV 00403. And as recently, it's Harper versus Z2 Enterprises, and this time, Mr. Nazraoui. Finally, they are bringing Mr. Nazraoui into the case and giving him the opportunity to oppose the very thing that he's suffering from now, which is in effect a judgment on executions are on judgments, and there's no judgment against Nazraoui on the claim that would bring them into liability. The court denied an attachment attempt earlier this week or last week. Judge Dupuy in the Superior Court, Mr. Donovan had ultimately or finally brought a suit alleging piercing the corporate veil, which is what he's trying to ride the coattails of in the case that's before you now. The appeals court, I have 58 seconds left, I think. The appeals court is the only vehicle that Mr. Nazraoui has at this point to try to get rid of this attachment. There has been no intervention. There's been no veil piercing, either by way of proof or by claim. When it's alleged in the supporting paperwork from Mr. Donovan and the other cases, it's always ambiguously phrased. And every time he mentions Z2A or the other guy, he puts comma Nazraoui. And then I would say that the sheriffs and the writs and the court stumbled into putting Nazraoui on the writ that was filed in the Registry of Deeds. And every bank in this country is going to deny Mr. Nazraoui the ability to refinance or do anything unless and until that attachment is taken care of. So I would implore the court. Pardon me?
That's the point of it.
Yes. So we've never been a party. We're still not a party. There should be no judgment against us. And even if we were a party, when the appeals court looks through the record, you'll see that there is nothing in the way of proof or support, even by affidavit, to support a piercing the veil, even if it were claimed. Thank you.
Thank you, Attorney Beauregard. Attorney Donovan. You have to unmute yourself, sir. We muted you, but you have to unmute yourself. There we go. Oh, there you
go. Thank you, Your Honor. Mark Donovan for the appellee and plaintiff Amanda Harper. My brother's point was his client was never a party. That was by his choice, Your Honor. My client filed this back in the MCAD back in 2014. Z2A was a going concern at that time, received a judgment. They were aware of the proceedings there. They actually filed a response to our complaint there, but then chose to default. And after 2 defaults and hearings, my client was awarded a judgment. Again, we filed to enforce the judgment in Superior Court.
The judgment wasn't against Nasrawi, right?
No, it was against Z2A Enterprises.
No default judgment.
Excuse me.
There was no default judgment. You said that they had defaulted.
There was a default judgment in Superior Court against Z2A Enterprises.
But not against Nasrawi.
Not against Nasrawi named. Okay. But as far as the service went, he was the only director, president, and officer of the company at the time. So he's fully aware that the litigation went on in the MCAD. He was served at his home at the same residence that was the subject of the attachment as the only officer listed with the Secretary of State. He chose there not to respond to the litigation in Superior Court. He defaulted there, did not file an answer, or Z2A did not file an answer. At that time, my client filed for an attachment, and I would argue to the court that this is a question of whether the trial judge had discretion in order to allow the attachment on the residence and pierce the corporate veil. There was no cause of action for pierce the corporate veil because it's not a cause of action. It's an equitable remedy. It's a remedy of the court. And there's nothing in the rules that say, no hard and fast rule that my brother has cited that say that an attachment cannot be placed on a third party or someone who has to be the named defendant. There's no cases to that. In fact, in my brief, I inserted 2 cases where they did in fact attach property that was not of a named defendant when it was attached. It was in the possession of third parties. As far as the service was concerned, it was served to Z2A and to the only corporate officer at the only corporate address that was ever filed with the Secretary of State. That was willfully ignored again by Mr. Nasrawi, the only director, the only employee of Z2A Enterprises, and defaulted again. Since then, there was no, Z2A never filed any notice of appeal of the judgment or notice of appeal of the order. So Z2A never filed anything to appeal that. And then several months later, there was the first motion to dissolve as a third party coming in. So Mr. Nasrawi is trying to come in as a third party, but yet never came in representing his company or having any corporate counsel represent his company as the only officer and director.
I was looking at the document. So the judgment, the default judgment was December 14th, 2017. Yes. And then the first motion to dissolve, the emergency motion to dissolve, was August of 2018.
That's correct.
Denied August 1, no notice of appeal, perhaps predecessor counsel, but no notice of appeal. And then a few months, 8 months later, essentially the same motion is filed again and denied again.
That's correct.
And only then is there notice of appeal filed.
That's correct. And at that second motion, the Judge Renee Dupuy actually ruled that there was a likelihood that my client would be able to pierce the corporate veil. And that was part of her decision of why she denied the motion. And I would submit to the court that this was in her discretion based on the totality of the case and also the case history of where Mr. Nazraoui has decided to not follow the judicial system, just ignore the case and allow my client to continue to chase and figure out a way in order to get her judgment. So I would,
I take it the attachment, you can't execute on the attachment at the moment because of this appeal.
Because of this appeal and the second action that I filed naming him is in a way to kind of ensure if the appeal is unsuccessful for my client that we have some kind of recourse, essentially.
If we were to affirm the attachment, would your second case go away?
I don't think it would go away because Mr. Nazraoui has never, the attachment would remain. I would keep my judgment, and until Mr. Nazraoui would like to speak about settlement, it would just remain in. And so so I have to keep finding other ways of executing the judgment because I can't execute it. Or I could ask the sheriff to execute the judgment.
But actually you can't, I mean, you still have another step to go. You still have to pierce the corporate veil to be able to actually get to the property.
I would argue that this judge in this court has pierced the corporate veil in her decisions and in the judge allowing the attachment, saying that I would show a likelihood of piercing the corporate veil.
And what's your, I'm sorry, what's you, in your brief, you say a couple of times you say that Z2A was involuntarily dissolved, and the site for that is just a copy of the Secretary of State filing, which doesn't mention dissolving on it. What's the other, was there any evidence in the record about why or how it was dissolved?
Not in this record. I believe that for some reason that page was omitted in the filings with the Secretary of State or the printout of the Secretary of State. But if you went onto the Secretary of State website, it would show that it was involuntarily dissolved. That's how it's listed presently, as involuntarily dissolved in 2017.
Oh, well, I think we understand your argument. I don't see any other questions. If you have 7 minutes, but you don't have to use them.
Thank you. I just wanted to stress that under the statute for the attachment, it doesn't limit the court in finding equitable remedies. And there's no reference in section 223, excuse me, chapter 223, section 42, makes no reference that it has to be the defendant's property. And so I would leave it to the judge's discretion. And I think with the history of this case where the defendant Z2A willfully defaulted at the MCAD and then willfully defaulted for the Superior Court, now Mr. Nazraoui comes in as a third party, non-party, essentially shirking his responsibility to the company, saying that he is completely unrelated to the company, even though he is the director, the president, the sole shareholder, operates the company out of his house, and asking the appeals court to rule in his favor several months after allowing these judgments without any appeal from Z2A as the party.
I have a question. When you mentioned that the Z2A was involuntarily dissolved in 2017, do we have in the record a specific date in 2017 and specifically whether it was before or after November 1st of 2017 when there was that service of the petition on Sandra Nazraoui at the Mr. Nazraoui's address, as shown at page 128 of the appendix?
I believe it dissolved before service. I thought it was part of the record in the lower court, the exact date. But I would argue to the court that it's not actually relevant because the party, Z2A was a going concern when the MCAD case was filed and adjudicated and decided. So he was fully aware. It's really just a petition to, it's not a new complaint, it's a petition to enforce.
Anything else you want to add?
Just that also that the timing of the appeal is very complicated. It just seems that under the rules, it should have been filed within 30 days. And the second, now they're appealing basically a motion to reconsider or a second independent motion that was already denied.
But if the judge rules on it again, doesn't that change everything?
If the judge rules on it again, excuse me, do you mean the lower court judge?
Yes.
I think she ruled on it as a motion to reconsider because she ruled on the previous one, but she did not write a written opinion. She simply denied the motion. And I think she took it, if you look closely at the record, I think she took it as a motion to reconsider.
And you can appeal from that.
I would say yes. However, when you're filing a motion to reconsider, there are also rules about when you can file that within 1 year unless other good cause is shown. These motions were all filed well after the original attachment. So no motions were ever filed regarding the original attachment. It's just the motions to reconsider and the motions to dissolve from the third party Nisrawi. So the problem, it is problematic, but the problem originally occurred when Z2A defaulted and did not answer any of these complaints or participate with the legal system. And it is worth noting that Rene Dupuy did find a likelihood of piercing the corporate veil. And again, I would just state that that's a remedy for the court. It's not a cause of action. You don't list it as a cause of action. That's a remedy, and it falls under the discretion. So if the court were to rule against Harper, the appeals court might be making a hard and fast rule that it has to be the defendant's property to be attached, but that is not the way the attachment statute is. There's no hard and fast rule that it has to be a named defendant or in the case in order for attach a property. It's about the discretion of the judge and based on whether the facts would allow it. And these judges found their likelihood of piercing the corporate veil. The original judge, I would argue, that's what he found and thought it was appropriate for the course. Appropriate for the case in order for Harper to try to maintain her judgment against the corporation. If there are no other questions, I'll rest on my brief.
Hearing none, thank you both.
We argued to him, Your Honor, if you're going to disclose and violate Rule 17A and the rule against insurance on the plaintiff side, logic would dictate you have to do that on the defense side. But of course, the judge here created incredible prejudice by telling the jury not only that although Amica was allowed to pursue in the name of its insureds, and Judge Henry allowed a motion pursuant to Rule 17A earlier in the case to allow Amica to sue in the name of its insureds, as happens every day in the Commonwealth in subrogation cases. He violated that by saying not only that Amica is the actual real party in interest, but more than that, they had paid approximately $4 million to Mr. Antoniadis, and that was the money that they were seeking.
On your issue about agency ownership or control under Mass Guide to Evidence Section 411.
Yes.
What do you say to the argument that the evidence about insurance was going to come in on the factual issue about who was the general contractor and whether there was a general contractor?
Yeah, the issue there is, of course, that it didn't need to come in on that issue at all because it really wasn't relevant to that question. If in this case BASNIGHT wanted to question Mr. Antoniadis about his conversation or statements, of course, there was no need to bring up the idea that it was made in the context of the adjustment of the insurance claim. He could simply say to him, as he did you make this statement? He could be confronted with it. And likewise, Mr. BASNIGHT could say what he said, which is that there was some question about cost savings because Mr. Antoniadis didn't have a general contractor. So the point there is it didn't have to come in. The only reason it was coming in was to taint the jury.
But doesn't it make a difference who Mr. Antoniadis is saying these statements about general contractor or no general contractor? If he's saying it to a neighbor, it might be a different, have a different evidentiary value than if he's saying it to his insurer.
Well, I'm not sure that's the case, Your Honor. I mean, if somebody makes a comment, they either make it or not. And Mr. BASNIGHT was there able to testify to his version of the events. And there was no real evidence that there was a credibility issue that they were trying to attack about Mr. Antoniadis because he frankly said he remembered it differently, but there was no buildup of that. And if you read the transcript, they didn't really try to use the fact that it was made to an insurance company to somehow impugn or attack his credibility.
You're saying a statement against interest is a statement against interest no matter who it's given to.
That's right. And it's similar, I guess, to a typical auto accident case where the liability insurance company goes out and gets a statement from its own insured. That statement is often disclosed. At trial, people don't get up and say, what did you tell your liability insurance company? They simply say, isn't it true that on such and such a date, you said this? And if they say no, you can confront them with the statement. It's why the taint that's created by insurance, it has to be guarded by the gatekeeper, in this case, the trial judge.
Well, about the gatekeeper, I mean, ultimately, this is an evidentiary ruling, so it's an abuse of discretion sort of standard. Would you agree?
I don't at all, because I think there's two issues. One, Rule 17A is a hard and fast rule. And so the Lonergan-Gillen case says if you violate a hard and fast rule, that's prejudicial in and of itself. So I think it's prejudicial error, Your Honor, when he violates Rule 17A and tells the jury that it's not Mr. Antoniadis that's the plaintiff, that it's actually Amica.
Do you have any cases that say it's a violation of Rule 17 to tell the jury that the insurance company's involved?
We don't have any cases, but I think
it's a hard and fast rule.
Well, because it's a rule of the civil procedure, Your Honor. It's Rule 17A, and it's a rule that Judge Henry, in this case, certainly acknowledged when he allowed Amica, over no objection, to sue in the name of its insured.
The rule starts by saying that only the true party in interest can sue. And then it goes on to say that for the purpose of this rule, the insurer, as acting as subrogate, is the true party in interest. I don't think it imports the collateral source rule.
I think what the rule says is an insurer who has paid all or part of the loss may sue in the name of the insured whose rights it is subrogated.
And you were allowed to do that.
Yeah, that's the rule. I mean, the rule says you're allowed to do it. We tried to do it in this case. And then the judge in this case guts the rule, ignores the prior
Well, then
ruling.
you're talking about the collateral source rule, not a violation of 17A, but the collateral source rule.
Judge, I think he did both. And I think he further compounded his error by saying to the jury, Amica's the plaintiff, even though Mr. Antoniadis is named as the plaintiff. Amica paid out this money. But by the way, then every time he said it, he would say to the jury, but leave insurance out of the case, or it has no bearing whatsoever on the questions you need to decide, which again begs the question, why even mention it in the first place? All it does is create the prejudice that all of these rules, the collateral source rule, the rule against insurance 411 and 17A, all of them are designed to prevent. And the judge was suggesting that it was misleading to identify or tell the jury that Mr. Antoniadis is the plaintiff. It was not misleading as well. He didn't understand. He suggested there'd be a double recovery or that there'd be further recovery. That wasn't the case at all. Really, what Amica was trying to do is get back the tort damages that Mr. BASNIGHT caused.
Your time is running low, so I just did have a question about the issue about the jury instruction on the assumption of duty. Was that your theory all along?
Well, it was because, of course, Your Honor, we didn't have a written contract that was agreed to by both sides. There was certainly an agreement that was circulated, but it wasn't signed. So our position always was that based on a course of conduct, in this case by Mr. BASNIGHT, that he voluntarily assumed the duty to supervise or oversee. And we had ample evidence of that from witnesses, from Mr. Antoniadis himself, from the billing records where he's billing for things going on the site when there's only construction, from his interaction with the town officials where he's signing building permits. So I think the judge clearly erred in not providing a special question on the verdict slip about the voluntary assumption. And essentially when he on his own accord inserts the words, did the plaintiffs agree? There was a death knell right there to the case, because of course there was a disagreement about whether they had contractually agreed, but there was an ample evidence of an assumption of duty. And the restatement of torts 323, which we cite, restatement second, clearly says that you can undertake voluntarily a duty for consideration. So once we identified the voluntary assumption as a material issue of fact, then the law says that it's mandatory. The judge has to do one of two things. He's either got to include that question of fact on the verdict slip, which he did not, and he was asked to, or if he wants to take the alternative approach, he can say to the jury, I'm going to instruct you, was there a duty of care, yes or no? And then he can give the subsidiary instruction about whether there was either an agreement, as he put it, or there was a voluntary assumption. But here he didn't do either of those things. And again, that created a prejudicial error. The idea, which you may hear of, that there's no difference between an agreement and a voluntary assumption really is belied by the judge's own comments. He said, of course, there is a difference. He said in the charge conference and elsewhere that he thought there was only going to be an issue of agreement, even though we repeatedly asked him to instruct and question them on the voluntary assumption of a duty. But I thank you, and for the rest, and we'll rest on our brief for any other questions. Thank you.
Any other questions from the panel? Thank you very much, Mr. Donnelly.
Thank you.
So Attorney Newberry, you for the appellee.
Good afternoon, Your Honors. Can you hear me?
Yes.
Okay. Yeah, I represent both the firm BASNIGHT Buckingham Partners and Walter BASNIGHT individually. Thank you for your time. I want to emphasize something that one of the judges brought up earlier. This is, I think, clearly an abuse of discretion standard here. As an evidentiary ruling, Rule 17 does not say anything about whether insurance can be mentioned. It explicitly says that the insurer may sue in the name of the party. That's all it says. It doesn't say anything beyond that. Even some of the cases that my brother cites to show examples where the concept of insurance comes up. And I think the issue here, and I also want to point out, Judge Barry Smith did not, this is sometimes in a trial, a judge has to make a snap decision on the fly. His testimony is coming in. This wasn't one of those. I'm pretty sure this is in the record at one of our argument sessions on this issue. He went back and after hearing us argue the point, he went back and conferred with other judges. He didn't say who, but it's Middlesex, so presumably there were several he could talk to before he came out with, I think, a very considered written opinion. So he obviously thought this through, and I think his discretion should be respected on that issue, even if you would have come down differently yourself. Really, though, this comes down to the issue of prejudice. My brother argues prejudice, and he argues that, and that's the reason why we try to keep the concept of insurance out of cases. I think we all know that. But the prejudice argument goes both ways. And to put it bluntly, to defend my client properly here against the central charge in the case, I don't know how I could do without even mentioning Amika's involvement. And that's because if you look at page 56 of the appendix, in their response to my motion to eliminate and preclude some of their expert testimony, right on the first page, they state right off the bat, they weren't suing my client in his capacity as an architect, but in his capacity as a general contractor. Now, my client was in meetings with Amika, with Mr. Antoniadis, where he actually argued not only that he didn't hire a general contractor, that he acted as his own general contractor. And he did that. I don't blame him for doing that. I think it was a decent argument to make to Amika that in terms of how much money he should get for settlement to rebuild his house, they needed to compensate him for a general contractor because going forward, he's going to have to hire one, presumably. So I don't know how I'm supposed to go to a jury when my client is being sued as a general contractor and say to Mr. Antoniadis, who's nominally at that point the plaintiff, right? The jury wouldn't know anything about Amika. It would just be Mr. Antoniadis, and say to him, you're suing my client as general contractor, correct, sir? Yes. But you had this meeting with whomever. You know, I can't mention who or what the context is where you said the opposite. It doesn't make any sense. It's sort of high.
And we have plenty of situations, I'm thinking on the criminal side, where you're in a proceeding and you want to bring back that someone had said something different. You know, you've taken a different position, a statement against interest, and you don't mention that there was a motion to suppress. You don't mention there was prior motion to dismiss or anything. You say in a prior proceeding or in another context, did you or did you not say these things? And that's it. That's all you need to do. You don't need to let the jury know about everything surrounding that statement.
No, I understand.
Couldn't that have been done?
I understand what you're saying, and I think the context here was important because it buttressed the truth of the statement. And again, you know, I'm not saying that this is that the trial judge's decision was a 100% slam dunk. He gave a lot of thought and consideration to it. My point is, I think it was the correct decision, but I don't think as a matter of law it was incorrect. I think it was a question of trying to balance prejudice between the parties. It's also why I touch on the damages issue as well. And now I did at the end of the testimony. On the last day, I decided to stipulate to the amount of damages. This was after I knew these rulings had already happened. I can guarantee you that if the judge had ruled differently and there had been no mention of Amika, I would not have stipulated the damages because I'm not sure Mr. Donovan would have been able to necessarily present in a way that a jury would have understood the damages without getting into this. Because this is not a situation where you can bring in a doctor to testify to medical records or what the costs are, or an auto accident case where you bring in an appraiser and just says, yep, the car was worth $10,000. There was a stack about yay high of documentation. It was going to take all day. It was going to have to have some random person who he can't identify come in. It didn't make any sense. So that's part of the reason why the judge ruled the way he did.
Well,
I just think
stipulated to the amount of damages and just read a stipulation into the record rather than having the Amika documents about the damages come in. Isn't that why you wanted to stipulate to the amount of damages as a way to backdoor in the Amika documents?
No, I actually only stipulated to the amount of damages at the end of the trial after these rulings had already been made. If I hadn't agreed to stipulate, then Mr. Donovan, I don't have the burden of proof. And I know he could have proved it, but I would have made him put his proof on, in which case he would have had to put on all of these documents. Even if you redact Amika, the jury's going to have some semblance of what's going on anyway. My point is it was impossible. And I think this is what Judge Barry Smith ultimately thought. I think it would have been impossible for the jury not to have some inkling that there's an insurance company out there. Common sense tells you if a house burns down, there's probably property insurance anyway. But I was just trying to make this case the true full of what it was. We never went to the jury and said, or made any arguments, well, this guy shouldn't be entitled to get money because it's really Amica. That wasn't the issue. The issue was trying to put.
Wasn't there an argument made that this guy had to fight with his insurance company for a couple of years?
Well, part of that was to show how my client actually helped him. I mean, part of the problem here was there was this weird dynamic going on because Mr. Antoniadis actually liked my client. I think he's testified he did a good job. He was the plaintiff. In fact, at one point he testified he wasn't even aware he was the plaintiff. And then he said at another point that he had no evidence. He said this is deposition too. He had no evidence my client had done anything to cause the fire. So if you think about it for a second, if the jury knows nothing about Amica, it's just, I'm going to call them George and Walter. It's easier than using the last names here. George, the plaintiff, and Walter, the defendant. And that's all the jury sees. And they hear George, the plaintiff, say, essentially, oh, I don't think Walter did anything wrong. As a juror, aren't you going to sort of sit there and go, why are we here? It doesn't make sense. It's sort of a false presentation of the reality of the case. And I think the trial judge handled it properly. I don't think it was an easy thing to balance.
Isn't that advocating just really abolishing the collateral source rule because everybody knows that lawsuits are fueled by insurance?
No, I don't think the collateral source rule has any applicability here at all. I know at the beginning of Mr. Donovan's argument, one of the judges, I forget which one, asked him, basically raised the same issue. The collateral source rule is about preventing juries from either thinking that a plaintiff has already recovered money, okay, or thinking that a defendant has insurance, therefore who cares, the insurance company will pay. No one here was suggesting that Amica wasn't, if liability was found, that Amica wasn't entitled to its damages. That was never an issue in the case. I don't think any juror, I mean, I don't know, I didn't talk to the jury, but that was never the issue.
Wouldn't the jurors think for the same reason, who cares? It's, who cares if Amica's out a few $1 million? They got plenty.
No, I understand. Like I said, when Mr. Donovan says that he thinks there might have been some prejudice to his client by mentioning Amica, I'm not going to argue that he's wrong. On the other hand, I'm saying there was also prejudice to my client given the unusual circumstances here by not allowing me to at least touch on the fact they were there. I think it would have been confusing to the jury. So it's a balancing of prejudice, in which case I would go with the discretion of the trial judge. I think if he had ruled differently and gone the other way, I might be the one up here on appeal arguing the opposite of this and Mr. Donovan, but the truth is this is a trial judge issue, I think, and I think he did it fairly.
Can I ask was the issue of your client's insurance actually raised during the proceedings at all?
No, it was never brought up. In fact, my client doesn't, it's not relevant. My client doesn't even have any indemnity coverage because he has architectural coverage. So it was definitely never brought up.
I asked that because one of the things in the Attorney General's brief is that he wants to strike actually that portion of your brief where you mentioned that. And I think so it's not part of the record, right?
No, it was never brought up. So anyway, I don't know if you have any questions more on that topic. I don't want to repeat what's in my brief. I just want to emphasize again that their case was predicated, and it evolved. I know it evolved a little bit, but I do want to stress one thing. I said in here in my brief a couple of times too, that even if you found there was an error here, it's harmless error. I don't want to lose sight of what this case was about. Mr. Soares, the paint company employee, he left oily rags in a bucket that caused the fire. The plaintiff proved that, and for purposes of appeal, I haven't disputed it, though I did try to, argue at trial a little bit. But for purposes of appeal, that's what happened. He was there at 9 o'clock at night. My client never knew who he was. I think he met him. Mr. Soares testified that he might have met my client once for, said hello on the job site. My client didn't hire him. He had no contact with him. He didn't pay him. He had no idea he was even there doing the floors. In fact, Mr. Antoniadis was the one who was there that night. When he left him alone in the house. And beyond all that, if you're talking about really, if you think about the theory here, what is my client supposed to have done? Because the testimony, it's undisputed, whether it's true or not, I don't know, but it's undisputed testimony, is that Mr. Soares knew all about the risks of, this is what he said, and his boss said, knew all about the risks of spontaneous combustion and knew how to properly clean up after himself. So even if my client had hired him, let's say my client had been the supervisor or manager or voluntarily assumed a duty or anything like that, what was he supposed to have done differently? Stand there and watch the guy do his work? I mean, it doesn't make any sense at all. And I think had the jury come back a different way, I definitely would have filed a motion for JNOV. I don't know what the trial judge would have done, but there was literally no evidence to tie any negligence to my client, regardless of what his role was. So any error you may find, I think, is just harmless error under the facts. I know it's a fact issue, but sometimes a fact issue is so clear cut, it's not really a fact issue.
Could you address the issue of the assumption of duty argument and the judge's failure to give an instruction regarding that or a question regarding that?
Yeah, I mean, as I said in my brief, at some level, I I'm a big fan of specific jury questions. I think they've become more and more common, but they're not required by the law. I think that also is it's a discretionary issue for the trial judge. I think the question you gave was appropriate. I don't think to a layperson, again, I say as lawyers, I know we parse this stuff. I don't think to a layperson there was much of a difference in the question he gave versus what Mr. Donovan wanted him to get.
When you say, did the parties agree, that nullifies the assumption of duty theory, doesn't it?
Well, what was the evidence
if you have
that my
an agreement? It's not simply an assumption of duty. Isn't predicated on an actual agreement. That's a contract.
I understand what you're saying, and as a lawyer, I understand that. I'm saying I don't think to a layperson jury they would really make much of a difference. But I also, where's the evidence that my client? There's no evidence my client assumed a duty to supervise ShineStar. Literally, remember, the undisputed evidence is my client did not know who they were, or that they've been hired, or that they were on site. So whatever other duties he may have assumed hypothetically in connection with the rest of this project, there's no evidence he assumed a duty with respect to ShineStar anyway. There literally is a gap in the record. That'd be a directed verdict question anyway. I don't know if that's why the trial judge didn't put that in there, but because my client had agreed in a contract way to be the site supervisor, that would give him control over everything. But to say he voluntarily assumed a duty to supervise this particular contractor, which is essentially what the issue is, there's no evidence of it. So I understand what you're saying, Your Honor. I don't think it's much of a distinction for the jury. I think it's a discretionary issue. But even if you would have given a different instruction, again, it's harmless error. This case, we were brought into the case only because of deposition testimony of Mr. Machado, who gave some erroneous testimony in his first deposition that my colleague, my associate, when she deposed him after we got brought in, because of that, cleaned up. Otherwise, we wouldn't even be here.
So you're saying it's harmless error because there was insufficient evidence to support that theory?
Yes, I think there was, with respect to the actual cause of the fire. I mean, again, it's undisputed that my client did not even know ShineStar Painting was on site. In fact, he never heard the name Soares until years later. I mean, I had no idea. In fact, I think one of the oddities is I don't think my client even wanted the stairs stained. I think he testified about having an aesthetic dispute with the owner about that. So the owner went out and did it on his own. So there we are. It's just it's a bizarre case. I mean, there was a legitimate claim against the contractors, obviously, and that's why they settled. But here I am left. I mean, it's been 8 years since this happened. Anyway, those aren't really relevant to the appeal. But that's I will rest on my briefs unless you have questions about anything else.
Seeing none, we'll take the case under advisement. Thank you both very much. It's a very interesting case.
All right, we are now live and recording.
Thank you. Good afternoon and welcome to the Massachusetts Appeals Court oral argument session for October 22, 2020. This is the last case today, and we have a slightly different configuration of the panel. Judge Singh and I are joined by Judge Wendlandt for this argument. As you know, this case is being argued on Zoom and live streamed on our YouTube channel. We'll follow the same rules as in the physical courtroom, except you can remain seated while you're speaking. As you can see, Attorney Michaud has had a little bit of technical difficulty today, so we can hear him, but unfortunately we're unable to see him. He can see us, and he's assented to having Attorney Shorey visible to us while he's not. Once we get going, the session clerk will put a clock where the insignia is, and you'll have, as usual, 15 minutes to argue. There's no rebuttal. And the advocate who's not speaking will be muted. Mr. Shorey, we can see you. So keep while Attorney Michaud is arguing, please keep your reactions to a minimum. As always, we've read your briefs. We're familiar with the case. So, and although you have 15 minutes, you're free to end early if you don't need them all. With that, Attorney Michaud.
Good afternoon, Your Honors. I represent Junior Gray in this matter in Commonwealth versus Junior Gray.
And it's Commonwealth versus Junior Gray, 19P405.
Yes. And there are two issues here. One is with respect to the photo array, and the other is with respect to the motion to suppress. I'll take the photo array first. And as outlined in my brief, the photo array was done. The victim was transported to the hospital immediately after shooting, was sedated to some degree. There was some medications. I'm not sure if that ever came out exactly what medications he was on, but he was sedated. and he had presumably his girlfriend was there, whether outside the room and came in the room or not. That's a little bit up in the air. But with respect to the photo array that was shown to the victim, there doesn't appear to be anything that's objectionable to the first showing, with the exception that Detective or Officer Young was known, who showed the lineup, did know the defendant. Defendant Junior Gray was a suspect in the crime.
Although wasn't there testimony that he didn't know which picture was the defendant?
Exactly. So the issue, I think, really is the second showing, and I understand that, people can certainly say, well, wait a minute, let me take a look at those photos again. That is a possibility. I accept that can happen. I guess the issue is that we don't really know how that second lineup or showing took place, because it was never recorded. The recording was shut off, and although it may have been an unusual set of circumstances, I believe the police should have certainly taken steps or measures to make sure that it was done in a proper fashion, and that wasn't done. And so the issue is whether or not.
Excuse me, counsel, what in your estimation was improper specifically?
Well, a couple things. One is that we don't know if there was there was one statement made by the officer that I know it's tough or something to that effect. And the victim did say, I don't think so, when the defendant was pointed out as to whether or not that was the person. So I think when that lineup or that showing is extended to a point where it may give a victim a false sense of knowing or thinking he knows who might have shot him, I think that's where the problem arises. That it becomes, how do we know that didn't impact the victim in his identification, especially where he said, I don't think so. It wasn't even if he said, I'm 50% sure, 75% sure. He just said, I don't think so, which would lead me to believe that he's not even 25% sure. So I think that's the issue on whether or not, beyond a reasonable doubt, there's harmless error. I don't know that there's much more.
But before you get to the harmless error, don't you have to establish that there was actually error? And so my question to you was, what made this procedure unnecessarily suggestive as required? Which was your burden to show.
Right. Some of the case law suggests that if there's a second showing, and granted this was a second showing immediately after the first showing, but when there's a second showing, that can impact the victim's ability or his likelihood to possibly false identify someone. So that, I would say, was an improper method of unnecessarily suggesting that the defendant is in that lineup, and when he said,
I'm going to interrupt you. Isn't in those cases, isn't the difference that the police instigated the second showing, where here it's the victim who asked for the second showing?
I don't necessarily recall 100% if that's, but I would not doubt that that's the case, Your Honor. And so yes, this is a little bit unique. And at the outset of the argument, I did state that is, and it's understandable, and I think it's reasonable to believe that the person may have said, hey, can I see those again? I'm not going to discount that that's a possibility.
Did those cases involve the same photo array being shown twice to the victim?
In some of the cases I found that the issue, there weren't that many. I don't remember being that many cases, but that there were.
Well, I guess let me reframe my question. What's the best case that you have that you're pointing us to? In that best case, was the victim or the eyewitness shown the same array twice?
I wouldn't be able to answer whether or not they were shown the same array, exact same array twice without going back to the cases. But Emerald, 4246, Mass 618, 1997, I would say is one case that would be in support. I know that there were a couple other cases that I did reference in the brief, but I would say I would refer to Emerald. I believe that's how you pronounce it.
So in terms of are you pressing the argument about it not being recorded the second time?
I think that certainly throws into question as to whether or not there was any possible other suggestiveness involved. Clearly, they had a suspect. The police had a suspect. They knew who it was. I'm certainly assuming they wanted to be able to arrest the suspect if he was the responsible party. So I think that leaves some question as to whether or not there was additional suggestiveness. And again, the fact that it wasn't recorded and that he was unable to identify it the first time, I think kind of throws that into question a little bit more. Other than that, the record is what it is. I don't have much more that I can provide on my end.
But didn't the judge do the proper thing and just let it out before the jury?
I think my memory is that did she say that it was being there was going to be the weight of the evidence was the issue, not the admissibility?
Right, so it was a matter of weight, not admissibility.
Correct. So I understand that, but I still think it was unduly prejudicial. So that's the defendant's argument that it was unduly prejudicial. But I do understand the judge's noting that in the record that it was going to be for its weight, not admissibility.
And I assume that in closing argument, trial counsel made all those arguments too, right? That there was a second showing and he was sedated and I would have to look back at the transcript, but I'm certainly willing to do that and write a letter in response. That's okay. We can do that.
Okay.
That was not a buzzer. Do you want? So can I ask you about your other argument? Now attorney. There we go. Are you back?
I'm here.
Okay. On the motion to suppress piece.
Yes.
You seem to argue in the brief that the protective sweep of the locked part of the basement was unconstitutional, and the motion judge agreed with you on that.
I'm sorry. Could you repeat that again?
Yeah, you argue in your brief that the protective sweep of the basement, the locked part of the basement, was unconstitutional, and the motion judge agreed with that, and said that nonetheless, the warrant, if you excise that from the warrant, there was still probable cause to do the search, and so it seems like you don't address that aspect of the judge's findings.
No, I didn't. I would say, Your Honors, that there was no exigent circumstances, and there was no.
Judge, everybody agrees with you. Nobody disagrees. So the question is, does it matter?
I think it does matter. I think it matters in terms of there was more than. Well, I do think it matters. I think it matters because it was more than enough time for the police officer to get a search warrant, and they failed to do that, and they broke into the locked premises. So I would suggest that right then that it matters. That I don't agree that.
But that violation didn't harm your client.
I would argue that that was part of their case, was that they found, I believe they alleged that they found some of his belongings down there. So I suppose it does tie him in to some degree. So does it harm him? I suppose it does.
So the case that you cite, Commonwealth versus De Jesus, they found, as you're arguing here, that it was an unconstitutional sweep. But then in the very next page, they go on to say that, but we're still not going to suppress, because if you take that away from the warrant was still sufficient. And that's exactly what I think Judge Raschuti did here. And I don't even think the search warrant application is in the record, is it?
I don't believe so.
We can't really even assess that. We don't have a record to assess that.
I don't believe it was. But at this point, I would just rely on the brief. I don't know that I'm going to be able to offer anything more with respect to oral argument on the suppression issue.
Any other questions from the court? Okay, very well. Thank you very much, Attorney Mashad. And we'll now go to Attorney Shorey.
Thank you.
Good morning again, Your Honors. I would just briefly address a couple of points from as to issue one. The first being the issue of the blindness, and I think the record is clear that Detective Young knew the name of the suspect, but did not know which picture depicted him, and didn't know what the suspect looked like independent of the photos. I would point you to transcript 4, page 141 for that, for the record support for that. As to the question on cases raised by the defendant addressing multiple showings of a photo array, by my reading of the record, I don't see any that involve a second showing of the same exact photo array. They involve showings of really different pictures of the defendant because there was some issue with the first one. For instance, no facial hair, or the witness mentioned the hair length didn't match the perpetrator or something like that. So I think this case is easily distinguishable from those cases, given that the same exact photo array was shown. It's hard to imagine in what sense the array was suggestive, given that every person in the array was shown a second time. As to the only issue I would address on the defendant's second claim, of course, I think the primary point on both of the defendant's arguments is the procedural one, that there was no motion to suppress filed as to the identification on the first issue, and the defendant.
Can I ask you, counsel, why do you say that? Wasn't there a motion to exclude in the record at, I think, 55 to 56? Why is that not sufficient?
Well, there's a motion to exclude at the time of trial and requesting of voir dire. Yeah. It's not supported by an affidavit or anything like that, to my recollection. But then the judge says, okay, I see why you're asking for this Dugan hearing. I don't see the basis for exclusion. I'll give you an opportunity to raise that. And the defense counsel says, if I have anything on exclusion, I'll provide it by the end of the day. And then that just never happens. And then the next day they proceed with trial, and the defendant has no objection to the admission of that testimony, and then affirmatively moves to introduce the recording as opposed to just the photo array itself with the writing on it. So, those points are apparently an affirmative concession that there's no argument for exclusion here. So I think the judge gave him the benefit of saying, maybe we didn't follow Rule 13 technically here, but I'll give you an opportunity to still raise the issue if you can before testimony tomorrow. And the defendant just never does that. But I think on the merits, the defendant clearly loses that claim as well. But on the second issue, I think the procedural claim is even clearer without the search warrant really even being in the record. But then I'll just clarify one point from defense counsel on the police finding something in the apartment and that being introduced at trial as part of the Commonwealth's case. I think that's really just as part of is pursuant to the search warrant items were found. The only thing that was determined during the initial sweep and that was included in the search warrant application was that it appeared to be a makeshift residence in there. So that's the only information that was included in the search warrant. If there are no further questions, I would rest on my brief.
Seeing none, thank you very much, and we will take the case under advisement, and that will conclude our oral argument session for today. I want to thank Clerk Tway for her excellent presiding over the Zooming, and with that, we'll be in recess.